programs. This is the best period for them to listen. Anong oras na ba? O 1:10 na pala eh. Alright, so we start with our... we pray first in the name of the Father, the Son, the Holy Spirit. Amen. Father God, we are here for this momentous day, for your children to learn something before they tackle the bar exams this year. We ask of you, Father, give them light, give them the proper guidance for them to accumulate all of this knowledge that I'm going to discuss. And I know, Father, that I'm also, you have also given me the graces and the blessings to discuss these pertinent areas, which will be the areas of the bar. We ask this in the mighty name of your Son, Jesus, and also the intercession of Mama Mary and all the angels and saints. Amen. In the name of the Father, the Son, the Holy Spirit. Amen. So let's start. Listen very carefully, no? Of course, I understand that one of the bar examiners is my good friend, Manong Doming Disini, no? Yun ang balita. And he's my colleague at UP Law Center. So just listen, people. We will start right away. You know, early birds catch the worm. So listen. So we start with labor law. And although I'm only assigned a particular area of labor law, I'm going to discuss everything. I'm going to discuss everything for you to have a basic foundation of labor law. Okay? Okay. So we start right now. Of course, when you talk of labor, strictly speaking, this may refer to physical or mental exertion or effort. But from the point of view of the Labor Code of the Philippines, labor is also treated as manpower. In other words, when you talk of labor people, labor, this may refer to manpower. They are used interchangeably. And what is manpower under Book 2 of the Labor Code of the Philippines? When you talk of manpower people, this refers to that portion of the population of the state that is necessary to produce goods and services. In other words, people, if you were asked in the bar on what is labor, take note of the term manpower. Take note of that. Of course, what is labor law? Of course, when you talk of law, labor law, this is a law that reads primarily on matters that involve employer-employee relationship. This may refer to labor standards law, labor relations law, social legislation, protective legislation, or this may refer to administrative legislation and diplomatic legislation. In other words, people, when you talk of labor law, this is an amalgamation of all laws on labor, such as protective legislation. What is protective legislation? When you talk of protective legislation, people, this refers to a type of labor law which is designed to protect certain workers from an unfair employment contract. So when you talk of protective legislation, mamay bigay sa bar. Give an example or exemplify protective legislation. Take note, pag binigay sa bar yan, the best example is a law on the protection of women or a law on the protection of children. In other words, people, when you talk of protective legislation, there are laws on this. We have laws on women, no? Give me an example of a law that protects a woman, aside from those that are provided for under the Labor Code of the Philippines. Oh, we have this Republic Act 6725, which prohibits certain types of discrimination. We have number one. What are the types of discrimination that are prohibited under the law? We have number one, discrimination in pay. Number two, discrimination in work opportunities. Number three, discrimination in hiring. And number four, discrimination in dismissal. You should know this. Ano malay nyo, ibigay sa bar? What are the types of discrimination that are prohibited under the law as affecting women? Okay? Bakit ganun? Talaga bang ganun? Ano yan? Jim. Kala ko babagsak na eh. All right, listen, Listen. So we have discrimination in pay, work opportunities, hiring, and dismissal. What are the other laws that protect a woman? Aside from these prohibited discriminatory practices. Ano ko rito? Nadidisturb ako. Kasi yumuyugyug eh, no? Hindi nyo napapansin, nayuyugyug. Baka mayugyug pati utak ninyo. Niyuyugyug ng gusto. Okay. Well, these laws that protect a woman, like what? Where we have this Women in Nation Building Act, a law which provides equality both of men and women in capacity to act. So imagine even women can now join exclusive clubs for men. They can now join the Philippine Military Academy. They can now join what we call the Philippine National Police Academy. Although these are school for men, but now they can join under this Women in Nation Building Act. Another, we have this law on the protection of a woman. Well, we have this Republic Act 9262, which prohibits worst forms of abuses. And what are the worst forms of abuses that are prohibited under the law? These are also criminal in nature. What? Physical violence. Ano pa? Sexual. Ano pa? Psychological. And the last one, what? Economic abuse. There are 4 types of abuses that are prohibited under the law. Physical, sexual, psychological, and we have this economic abuse. And for the first time in the history of Philippine jurisprudence, the Supreme Court applied this law in acquitting a woman employee who killed her husband because she has been afflicted with a battered woman syndrome. And this is the case of People versus Senosa. You know this already. And this law affects a woman employee. Take note of this. Ano pa? Laws that protect women. Oh, we have this law that provides for proper sitting facilities for women, di ba? Dapat kung halimbawa, she is employed in a factory and the machine is very big, she has to operate the machine, there shall be an elevated sitting facility provided a worker. Ay kung halimbawa, yung machine ay maliit tapos yung sitting facility mataas, hindi gaganon siya. Hindi pwede. Kaya nga tinawag na proper sitting facility. Ganon yun. Ano pa? Like in the case of a nursing woman. Kaya nga may nursery. Alam nyo, this might be inconsequential in your studies. Mamaya, banatan kayo ng bar examiner, gaya nung last year, tungkol doon sa private massage ng house helper. Oh. Dito, bakit kailangan may nursery? It is because of the fact that the government encourages breastfeeding. Di ba? Breastfeeding is best for babies up to 2 years, di ba? Also including 57 years of age. Breastfeeding is best for babies up to 57. Hindi lang 57. Kuminsan 75 pa nga meron di ba? No? Oh. So take note of this, no? Discrimination against women on what? On account of marriage. So we have a law on stipulation against marriage. There are cases here, the cases of Sialsita versus Paul. We have these PTNT cases, no? Where the Supreme Court ruled that a woman employee shall not be required to sign a contract of adhesion that should she get married, she will be dismissed. Stipulation against marriage. This is the case of Sialsita. You know, Miss Sialsita is a very beautiful woman. She applied the stewardess of Paul. She was taken in because of her erudition, because of her, she's of Caucasian look, no? She has a perfect Coca-Cola body. Coca-Cola body. So what happened? She was taken in, but she was required to sign an agreement. So what happened? After some time, because of biological reasons, she needs the caress of a man needs the caress of a woman. So what happened? She got married. She was dismissed. A case of illegal dismissal was filed against Paul. Paul argued that the contract is valid. Paul argued that if Sialsita is going to get married, she will be afflicted with an unknown malady. You know unknown malady? Di ba yung babae, pag buntis na, naglilihi na yan, hindi mo maintindihan ang ugali. Gusto yung kumain ng ubas na green, pwede. O mahirap nito, gusto yung kumain ng mansanas, pero bilog yung mansanas. Mayroon bang bilog na mansanas? Ano? She's afflicted with an unknown malady. Worse, sabi ng Paul, if she gets married, she gets pregnant. Ano sabi ng Supreme Court dito? The Supreme Court said, no. Wala naman doon sa decision yung no, of course. Ano? Sabi ng Supreme Court, getting married does not necessarily getting pregnant. One can get married without getting pregnant in the same manner that one can get pregnant without getting married. Select the best answer. Anong gusto nyo? Trial and error muna, no? Ang mahirap dito, wala pa tayong tubig dito. Bale, meron akong dalang fisherman's friend. Alright, let's continue. Well, nandito na tayo sa woman employee. Ang pwedeng ibigay dito is a bar question which I gave in 2008, but it was not given by Justice Tinga. Hindi binigay ni Justice Dinga dito. Yung bang a woman of a employed in a certain company is not allowed to marry an employee of another competing company. What is the primordial concern here, where as a general rule, a discriminatory practice is not allowed. Discriminatory practices of an employer are prohibited under the law. But this is an exception where a discriminatory practice is allowed. Because what is the primordial concern here? The business interest of the employer. For the purpose of protecting its interest. In order to protect certain confidential informations, in order to protect marketing strategy, in order to protect manufacturing formula. So what is the doctrine involved there? Sabi ng Supreme Court, this is the doctrine of bona fide occupational qualification test. So these are the standards. Anong tawag na sa standards na yan? This is known as the standard of reasonable test. Ba't hindi nyo pa ba na-take up yan? That is the case of Duncan. That is the Duncan doctrine. Standard of reasonable test. Or bona fide. Bona fide. Occupational qualification test. Hindi pa binibigay sa bar yan. Pwedeng ibigay sa bar yan this year. Knowing Doming Disini? Ano malay nyo? And don't ever fail to attend this up to tomorrow, until tomorrow. I'll give you all the bar areas of the bar. Bar areas mismo. Dapat ganun ang gagawin nyo. Makinig na lang kayo, hindi yung nagmumukmuk kayo ron. Yung paa mo, nanginginig. Hindi mo na alam kung anong gagawin mo. The best thing to do now is listen. Tandaan nyo yan. And in listening, you will pass the bar. I advise you. So listen very carefully. Hindi pa ata alam sa baba, nandito na ako, no? Hindi ako dumaan doon eh. No? Okay, let's continue. At saka isa pa, hindi naka-focus to. Di bali? Makikita kapangitan natin doon. All right, listen. So take note of this. Ang primordial concern dito, business interest. No? What is the applicable doctrine here? Bona fide occupational qualification test, or otherwise known as the standard of reasonable test. That is the Duncan doctrine. Nakuha ninyo? Okay, very good. So listen now. So one of the types of labor law is protective legislation. As I go on with my lecture, I will include yung mga bar areas na at saka yung mga hindi na bibigay pa sa bar. Ha? Kaya makinig lang kayo. Kahit kokonti kayo, okay lang. Many are called, but few are chosen. Ano malay nyo? Si Lord, sabi niya, kayo na lang ang pumasa. Ayaw ng iba eh. Wala tayong magagawa. Listen. I was made to understand that there are 1,200 here. But now, wala pang 100. Oh my God. Alam ba nilang may review ngayon? Sayang. Alright, makinig lang kayo. Listen. Another is this labor standards law. As defined by the Supreme Court, labor standards is a type of labor law that provides kaya nga tinawag na labor standards that provides the standards as to wages, hours of work, cost of living allowances, including health, safety, dental, medical, and compensation benefits. That is the maternity children's hospital case. That was the definition given by the Supreme Court. So listen, when you talk of labor standards law, these are economic benefits granted to a worker while the worker is actually working. Are there economic benefits that are granted the worker while the worker is not working? Yes. And this is the periphery, the area, the territory of social legislation. Let's take up first this labor standards law. Say, for instance, increase of benefits under the collective, increase of benefits under Article 121, 122, 123, 124 regarding wage orders issued. Okay. For a wage order issued by the Regional Wage Board, any increase of wages thereon shall be granted by the employer. So an increase of wages by virtue of the mandate of the Regional Wage Board, the employer should comply with such wage order or the mandate of the wage order issued by the Regional Wage Board. Do you follow? Is this a labor standards benefit? Yes, increase of wages is a labor standards benefit. Now, in the event that the employer does not provide the necessary increase under the Regional Wage Board, wage order issued by the Regional Wage Board, what happens, people? What happens? The employer is liable to pay double the amount of the increase of wages under the doctrine of double indemnity. Under the doctrine of double indemnity. Now, question. If, say, for instance, under the wage order issued, the employer does not grant or provide the wage increases, is the employer liable for unfair labor practice? Sabi ng Supreme Court, even if how unfair is the act of the employer, it is not an unfair labor practice unless it is in relation to the violation of the right of workers to self-organization. Kasi usually, ordinarily, ang sabi ng mga employees, hindi nagbigay ng aumento under the wage order. Oh, that's an unfair labor practice. That is not an unfair labor practice. Because when you talk of an unfair labor practice, this is always related to the violation of the right of workers to self-organization. Take note of that, people. Very important. Nakuha nyo? Now, when may an economic benefit or increase of wages an unfair labor practice? When the increase is provided for in the collective bargaining agreement. Under what clause is there any increase in the CBA? Oh, anong tawag doon? Where there is an increase of wages in the CBA, perhaps it's an across-the-board increase, or in case of sudden increases of consumer price index or cost of living index, there is a gradual increase of wages under the escalator clause in the CBA. Oh, alam niyo ba yung escalator clause? Oh, tignan niyo. Tanungin niyo yung iba kung alam nila yung escalator clause, wala sila. Paano nila malalaman ngayon yon? Eh, pag binigay sa bariyan, bokya. Ba't kukunti estudyante natin? Ha? Ano ba aga? Ano una medya na? Di bale. Basta ibibigay ko sa inyo lahat. Yung nga lang, bibisit ako. Kasi ako, maka-estudyante ko. Mahal ko estudyante. Tapos makikita mong ganito. Kaya nga pinasa ko nung 2008, almost 47% eh. Dahil sa pagmamahal ko sa estudyante. Tapos ngayon, they do not want to help themselves. Humingi kayo ng bago-bago naman. Bago lecture, dapat ang ano. Eh, na-prostitute na ng gusto to. Escalator clause. Listen very carefully. Thank you very much. Under the parties in a CBA may agree on clauses like no strike, no lockout clause, union security clauses, conclusive arbitration clause. Ano yung conclusive arbitration clause? Sige nga. Tignan nyo. Ang gagaling na nila. Umalis na sila eh. Conclusive arbitration clause is mandated by law that refers to the grievance machinery and voluntary arbitration procedures in the CBA, where the law mandates inclusion in the CBA. Otherwise, without such conclusive arbitration clause in the CBA is incomplete, inadequate, or substandard. Ano tawag doon? Sa CBA na yun, incomplete, inadequate, substandard CBA. That is known as a sweetheart contract. Or if the CBA does not provide the maximum economic benefits, the CBA is a sweetheart contract. That is not a sweetheart doctrine. Yung nababasa nyo dyan sa mga note-note na yan. Blue note, red note, diamond note, note. Mali-mali yung iba. Imagine doctrine ang nakalagay. That is not a doctrine. That is a CBA, which is incomplete, which is known as a sweetheart contract. Nakuha niyo? Alright. Escalator clause. What is this escalator clause? Escalator clause in the CBA provides that in the event of sudden increase of consumer price index or cost of living index, there is a gradual increase of wages. Yan. Kaya ko halimbawa, look at me. Let's have an optal intercourse. You know optal intercourse? Oh, you know that already. Yung nagyayarian, naghihindutan ng mga paningin natin, yun ang ibig sabihin no, baka hindi nyo pa alam. Oh, look at me. Halimbawa, may sudden increase of the price of oil. Di ba pag mayroon sudden increase of the price of oil, apektado lahat ang consumer prices. Yung prime commodities, nag-i-increase yan. Ano ang provided under the escalator clause? Pag nagkaroon ng sudden increase of consumer price index or cost of living index, there is also a gradual increase of wages. Do you follow? Nagkaroon na ng maraming increase of consumer price index, walang increase made by the employer. Walang increase. Is there a violation of the CBA? Yes. What is violated in the CBA? An economic clause. Now, kung economic clause or economic provision ang violated in the CBA, that is gross in nature. That is flagrant in nature, which is an unfair labor practice. So alam nyo na ngayon, increase of wages and the wage order is not unfair labor practice. But the employer is liable under the doctrine of double indemnity. But under this one, since it is provided for in the CBA, then the employer is liable for an unfair labor practice because a violation of the economic clause or the economic provisions of the CBA amounts to gross flagrant violation of the CBA. Maliwanag? Okay, makinig kayo mabuti. All right, listen. Listen very carefully. Okay. So we have these labor standards benefits people. Benefits or economic benefits granted the worker while the worker is actually working. Because there are benefits granted the worker while he's not working. Why? Because of the hazards of employment. What are the hazards of employment under the law? Under the labor code, what are the hazards of employment? Diyos mio. Occupational disease, which is compensable. Ano pa? Compensable injuries. Number 3, compensable disabilities. And number 4, you cannot avoid this because you are placed in a special box, drawn away by a special car, Mercedes-Benz or a Cadillac, with a throng of trumpets before your resting place, before you are laid in your final resting place. Death is the last hazard of employment. Meron bang benefits when an employee is disabled from working? Yes. Ito yung tinatawag na social welfare benefits. Kaya yung SSS na yan, JSIS na yan, yung Employees Compensation Law, Retirement Law, yan. Ano yan? Social legislations or welfare legislations. Why? They provide benefits to a worker while he is not working. Maliwanag ba? Okay. Bakit hindi siya working? Because of occupational disease. Nagkasakit siya. Ano sabi ng batas under the law? The disease is compensable if the disease is listed as an occupational disease. In other words, people, if the disease is not listed, it is not compensable. Nakalista lahat ng diseases under the table of occupational diseases. Halimbawa, bangungot, nakalagay doon, bangungot, o compensable. Ay, kung halimbawa yung bangungot, hindi nakalagay, compensable ba? It is not compensable. However, sabi ng Supreme Court, it does not mean that if a disease is not listed, it is not compensable. because the liberality of the law is still subsists, pursuant to liberal construction in favor of labor under Article 4 of the Labor Code of the Philippines. Take note of this. So, I'll give you a concrete example where Article 4, the principle of liberal construction in favor of labor is applied. Here is a worker who died of bangungot. Yung tinatawag nating hemorrhagic pancreatitis. Para hindi nyo makalimutan, pancreatitis, okay rin. Pancreatitis, ano yun? Bangungot. Ano nangyari ngayon? Namatay siya. The heir claimants, nag-file ng compensation claims. Sa private sector, SSS. Sa government sector, GSIS, and the Employees Compensation Commission. Sabi ng SSS, GSIS, Employees Compensation Commission, not compensable. Bakit? It is not listed. So what happened, people? When it is not listed, according to them, since it is not listed, it is not compensable. Do you follow? It is not compensable. But still, the heirs claimants pursue their case until it reached the Supreme Court. Ano sabi ng Supreme Court? Well, sabi ng Supreme Court, bangungot is a disease prevailing not only in the Philippines but also in other Asian countries. But medical fraternities cannot say with certainty as to the origin, etiology, origin of the disease. So, even medical experts cannot say with certainty the origin of the disease. Sabi ng Supreme Court, if these people cannot say with certainty the origin of the disease, therefore, it creates doubt, and the doubt must be resolved in favor of labor. Article 4, take note of that. Article 4 will make you a lawyer. It will make you a lawyer. Makinig lang kayo mabuti, ha? Kasi i-discuss ko lahat yung areas ng bar, pati yung latest mga pagbabago dito. Para you can struggle out in the bar where you are the winner, but the bar examiner is a fatality. Patay. Yung bar examiner, bakit? Nayari nyo siya. Hindi kayo binagsak. Listen, listen. All right. We have this occupational disease, compensable injuries. Expect the unexpected in the bar. Kasi kahit na Book 4 is not included in the bar, pwedeng ang magkakaroon ng tanong sa compensable injuries in relation to SSS and GSIS. I gave that in the bar. Nirelate namin sa SSS. Yung naghihintay ng taxi cab, tapos he was sideswiped by a speeding vehicle, nagkaroon ng injury. Yung injury or death as the case may be, compensable ba? Because he is on his way to work, allegedly on his way to work, waiting for a taxi or waiting for a ride, na-aksidente siya. Is the injury or death compensable? Ang marami nagsabi, because he is going to work, under the coming and going rule, it is compensable. You know, under the coming and going rule, if you were injured or died, as the case may be, it is not compensable. Because the Supreme Court had already decided that the employer or the SSS or the GSIS or the Employees Compensation Commission, as the case may be, is not an insurer to the safety of an employee. Halimbawa, lumabas ka na, you are waiting for a ride, na-aksidente ka, o kaya nasa loob ka na ng jeepney, na-aksidente, compensable pa rin yan? Sabi ng Supreme Court, it's not compensable because it is not an insurer of the safety. Because you are also exposed to the same danger as the traveling public. That is the principle there. Ay, ang maraming nag-answer. It's compensable. Pero binigay ko ron 4 points. Yung nagsabi ng compensable, 4 points. Sa kasi sabi ng yung answer ni Justice Tingan na pinrovide sa akin, compensable. Sabi ng UP Law Center, compensable. Sabi ng PALS, Philippine Association of Law Schools, compensable. Sabi ko, not compensable. Bakit? Nandun sa libro ko eh. Kung mali ang answer ko, bakit si Attorney Pokis mali yung nilagay niya dito sa libro? Tapos ganito ang answer niya. Sabi ko, not compensable. Not compensable. But compensable under the proximity rule. Kung malapit na siya, o papalabas siya, palapit na siya, within the periphery, within the working area already. Malapit na siya. Papasok o palabas. Under the proximity rule, it is compensable. Kaya yung nagsabi ng compensable, 4 points. Yung nagsabi ng not compensable, 5 points. Pag sinabi niya not compensable because of the proximity rule, 6 points. Kasi yung binigay ni Justice Tingaron, 6 points. Kaya tandaan nyo, it does not mean na pag mali ang answer ninyo, hindi na kayo makakakuha ng points. This is good. This is good in the essay type. Pero sa next year, wala na yan. 40% na lang essay type eh. Panay, multiple choice na. You should be exact. Yun ang problema ron. Dito, pwede pa kayong mag-reason out. So this is your last chance, people. Do it now. Pass yourself. Pass yourself. Ipasa nyo ang sarili nyo. Ha? Kaya makinig kayo. Okay? So, compensable injury. No? Now, disability. Mamaya tanungin, what are the types of disabilities? Hindi nyo alam. Simple lang, 3 lang yan. TTD, PTD, PPD. Ano yung TTD? Hindi nyo makakalimutan yan. TTD, Temporary Total Disability. PTD, Permanent Total Disability. PPD, Permanent Partial Disability. Hindi PEC-PEC-D, ha? PPD. All right, listen. All right. Compensable injuries. Isa pa, pwede kayong banatan dito. Sa injury na to, we have to relate it with another doctrine. Di ba? If you are injured or a worker died on account of performing an activity which is usually necessary and desirable in the usual business of the employer, the employee's injury or death is compensable. So it is the mandate of the Constitution and the Labor Code for the workers to be provided with conducive working environment. Like what? Providing certain facilities. Potable drinking water. Kung halimbawa doon sa working area, dapat may drinking water doon. Potable drinking water. Hindi naglagay. Walang accessible drinking area. Ano ginawa niya? He got out of the working area while crossing the street, na-aksidente siya. Is the injury or death compensable? Yes. The act of quenching your thirst is an act of ministration under the personal comfort doctrine. Tandaan niyo yung personal comfort doctrine. Sweetheart, yung nagbigay dito, nagbigay na ng bago. Sweetheart, Sweetheart, yan. Under the personal comfort doctrine. Nakuha niya? Personal comfort doctrine. What I gave in the bar was not, although it was also given in the bar yung doctrine, yung personal comfort doctrine. Hindi binigay ni Justice Tinga yung binigay ko kasi sabi niya, anong pinagbibigay mo, buddy? Kasi ang binigay ko ganito, walang comfort room, kaya yung employee, yung worker, umihi. Abang umiihi siya ron wala kasing comfort room sa working area, abang umiihi, he just look at the sky, not knowing dun sa baba, there are tall grasses, meron palang cobra. While urinating, not knowing that there was a cobra. The real cobra thought it is being attacked by another cobra. So what happened? He was injured. Is the injury compensable? Yes. That is an act of ministration. It ministers comfort and convenience under the personal comfort doctrine. Alam nyo na? Ayan. Related yan sa house helper. Providing comfort and convenience to the immediate members of the family. Is providing private massage part of the duty of the house helper in providing personal comfort and convenience to the head of the family? Of course not. Sasabihin nyo, it is not part of the duty of the house helper to provide comfort and convenience. Providing private massage is not part of that duty. So you know now, this personal comfort doctrine. And of course, we have death. That is the ultimate hazard of employment. You have to face the Creator. All right, listen. So we have labor standards. We have this social legislation. SSS, GSIS, Pag-ibig, PhilHealth, retirement law. According to the Supreme Court in Oro Enterprises case, is a social legislation. No? Employees' compensation law is a social legislation. All right, let's continue. Another. Excuse me. We have labor relations law. When you talk of labor relations law, people, this is a type of labor law which provides emphasis, which provides emphasis into the right of workers to self-organization, collective bargaining, and including peaceful concerted action on the part of the workers. Such as what? The right to picket, the right to strike, fair labor practices, unfair labor practices, the right to self-organization, the right to collective bargaining, the right to collective negotiations, etc. All of these are within the parameter of labor relations law. So in other words, labor relations law deals primarily on the concerted action of the workers. Take note of that. Now, labor relations law, konti lang binigay last year, but mas marami sa labor standards law is particularly yung Book 6, yung law on dismissal. Maraming binigay si Justice last year. Pero wag kayong maglala. Sasalsalin ko ng gusto yan. Ba't kayo tumatawa? Nakarinig lang kayo ng salsal eh. That is a journalistic term. Yung salsaldis, sabing ganun. Ibig sabihin, pagandahin, itama, bigyan ng style. Yan ang salsal. That is a colloquial term in writing, yung mga sa journalism. Tingnan nyo, pag may mga journalism dito, alam na alam nila yan. Pero ngayon, siyempre, first time niya makarinig ng gano'n, sabi niya, ay bastos. Ay bastos. Naku, ganyan. Alright, listen. Another, we have this administrative legislation. This is a law which designed to create labor bodies for administrative purposes. All labor bodies are administrative bodies. They perform also quasi-judicial functions. But of course, in the course of their performance of their functions, they are not governed by the technical rules of procedure and evidence. Technical rules of procedure and evidence are dispensed with in labor proceedings, which are administrative proceedings. And what is your legal anchor where technical rules are not binding but resort to amicable settlement? That's Article 221. Take note. Because the quantum of proof in regular courts is proof beyond reasonable doubt. But in labor proceedings, administrative proceedings, substantial evidence lang. Di ba? Substantial evidence. So take note of that. Now, we have the last one. This is a bar area. We have this diplomatic legislation. In diplomatic legislation, people, this is a type of labor law that provides the machineries of amicable settlement. Under the law, what are the machineries of amicable settlement? Or what are the machineries of settlement? Amicable. Kasi, so take note, amicable, hindi compulsory. So, compulsory arbitration there is not included. There is a distinction between voluntary arbitration and compulsory arbitration. Voluntary arbitration, the government does not intervene into the resolution of the labor dispute. Compulsory arbitration, the government intervenes into the resolution of the labor dispute. Ganun yan. So what are the machineries of amicable settlement under the law? Well, we have the grievance machinery and the voluntary arbitration procedures. Under the Labor Code of the Philippines, it is settled also under existing jurisprudence that the parties should include in a CBA what? A conclusive arbitration clause. Nga pala sa taxation ata, yung kasama ko sa tax na barig sa amin noong 2008, ibinalik siya. Si Mama Lateo. I understand, he has a book, di ba? Kung may libro kung sigurado kayo na siyang barig sa amin at talagang basahin niyo yung libro niya. Siyempre, ibibigay niya lang na within the confines of his book. Like in my case, ba't ako magbibigay ng libro ng iba? Siyempre, yung sarili kong libro. Ganun yun. Kaya ganun gawin nyo, ha? Yun lang chismis. Pero yung chismis, kung minsan, totoo yan. Di ba? Kaya kung si Mama Lateo, balikan nyo yung examination namin ng 2008. Balikan nyo yun. Baka ano malay nyo, ibalik yung mga 3, 4 na questions. So, yan. Si Dicini rin, 2 beses na naging bar examiner yan. Balikan nyo yung, nung siya ang bar examiner, alamin nyo, research that. Balikan nyo rin yung questions siya sa bar. Pero lastly, itong sasabihin ko sa inyo, before you enter the bar room, dapat sa first day, nabasa nyo na yung bar questions and answers ng UP Law Center. Yun the entire book sa political law at saka sa labor law. I'm telling you, 60 to 70% ibinabalik yan. Putulin yung et-et ko kung hindi totoo yun. Totoo yan. Bakit nga nyo? When I submitted my bar questions to Justice Tinga, bago ko i-submit, tinignan ko yung UP Law Center at saka yung bar questions and answers. Almost 60% nandun yung tinanong ko. Kaya I have to change some of them. Pero yung iba, sa pool pa rin dun eh. Nandun din eh. Kaya, anong the best dito? Di basahin nyo. The bar examiners, the bar reviewers will not say, ay, basahin nyo yun. No, they will not do that. Bakit? Gusto na lang sila lang abogado. Ayaw nila kayong mag-abogado. Simple lang yan. Ako hindi, mapagmahal ako. Papagbigay nga, pag may Sir, pagbigyan mo naman ako, sige ka ako. Biro lang yan, baka sabihin niyo, womanizer ako, hindi. Paminsan-minsan. Listen. We have this conclusive arbitration clause. We have the grievance machinery. The law does not provide for a step-by-step resolution of a labor dispute under the grievance machinery, but this is agreed upon by the parties, the employer and the union. But where in a grievance machinery, the parties were not able to resolve the dispute, after 7 days thereof, it is transmitted for voluntary arbitration. And of course, the voluntary arbitrator serves as an umpire or a third person that has the final verdict, and his decision has the effect of a res judicata. That's why the decision of the voluntary arbitrator is appealable to the Court of Appeals under the doctrine of high hierarchy of courts pursuant to the Luzon Development Bank ruling. Appealable to the Court of Appeals under rule. Anong rule? 43. Very good. In D65, it's Rule 43. Take note of that. The voluntary arbitrator. No? Okay, now, what are the other modes of settlement? We have the conciliation and mediation. By the way, before I forget, the law provides for a conclusive arbitration clause in the CBA. Therefore, if a notice of strike is filed, where will you file the notice of strike? BLR, ano ba kayo? You have to file it with the National Conciliation and Mediation Board. Ano ba kayo? A notice of strike is filed with the NCMB. I-discuss ko na nga ito. Mamaya mayari kayo. NCMB, ha? NCMB. Okay. So you file the notice of strike to the NCMB. On what grounds? There are only two grounds under the law: collective bargaining deadlock and unfair labor practice. The other one is economic and the other one is political in nature. All right. So we have this collective bargaining deadlock. Other authors say ULP. Other authors say union busting. Well, it is one of the strikeable issues, but it is still a species of ULP. Kaya actually, dadalawa lang. Eh sabi ng ibang authors, 3. Babayaan nyo na, pagbigyan nyo na, yun ang gusto nila. Oh, kaya 3 ang ginawa nila. Ako 2 lang. Collective bargaining deadlock and ULP. Okay. Assuming that the union filed a notice of strike on the ground of wage distortion problem, binigay sa baryan. That is not a strikeable issue. O halimbawa nga, nag-file ng notice of strike sa NCMB. The strike will be declared illegal because of the conclusive arbitration clause. It's premature. Bakit? Because of the violation of the conclusive arbitration clause. Kaya yan ang importante dyan. Kung may conclusive arbitration clause, you cannot file a notice of strike until and unless it is resolved amicably, your labor dispute. Assuming that they have complied with all the requirements, pero ang strikeable ground na sinabmit nila ay wage distortion problem. So it is filed with the NCMB. Once it is filed with the NCMB, finding on its face, nakita on its face, it is what? A wage distortion problem. Is a wage distortion problem a strikeable issue? The Supreme Court said no. It's not a strikeable issue. So if it's not a strikeable issue, what happens, people? What should the NCMB do? The NCMB shall drop the notice of strike from the dockets of notices of strike. And issue, ano ang i-issue ng NCMB? Kasi non-strikeable issue. Tignan nyo. Yung iba ayaw umatin. PMO. Ano yan? That is the preventive mediation order. Kala nyo na alam. Yung ibang mga bar candidates, kala mo alam na. Ayaw umatin. The preventive mediation order. And despite the issuance of the preventive mediation order, nag-strike pa rin. Itinuloy pa rin yung strike. The strike will be declared illegal. This is one of the instances under the law where the strike is illegal. A strike is staged in violation of the PMO. Preventive mediation order. Okay. Although the notice of strike is dropped from the dockets of notices, the NCMB will still continue to mediate. Kaya nga, preventive mediation proceeding. In other words, the notice of strike that has been dropped shall be treated or converted, shall be converted into a preventive mediation case. Nakuha nyo? So, the labor dispute now will now be resolved under a preventive mediation proceeding. And who will resolve it? The National Conciliation and Mediation Board. Makinig lang kayo sa akin dito hanggang tomorrow. You will have a batting average sa bar. I'm telling you. Kaya wag kayong don't be absent. All right, let's continue, people. What are other machineries of amicable settlement? Aside from conciliation, mediation. Oh, if you file a notice, if you file a case of illegal dismissal, the law requires that the parties should settle their dispute or the labor, the termination dispute not through a hearing but through a process known as preliminary conference, which is mandatory. So, bago magkaroon ng hearing on illegal dismissal cases, ano muna? Merong preliminary conferences which are mandatory before the parties are required to submit simultaneously their respective position papers. All right. Ano pa? Where amicable settlement is allowed under the principle of improved offer balloting and the principle of reduced offer balloting. During the bargaining deadlock or during the cooling off period, yan ang mga machineries. Grievance machinery, voluntary arbitration, conciliation, mediation, ano pa? Principle of improved offer balloting and the principle of reduced offer balloting. Where the parties, in the case of reduced offer balloting, the NCMB rin, the NCMB will conduct a referendum or secret balloting on the reduced offer made by the union in case of strike. So there was a reduced offer by the union. Kasi ang gusto ng union, malaking benefits. Ang sabi ng employer, sige, mag-ano na ako ng lockout. Magla-lockout na lang ako kasi sobrang kinukuha ninyo. Sabi nung mga union officers, members, nag-meeting sila, they came now into their senses. Alam mo, kung hindi natin pagbibigyan, hindi natin i-reduce yung demands natin, economic demands natin. Tayo rin ang kawawa. Mamaya, magsara na ng kumpanya. O sige, i-reduce natin yung offer natin. Yun tinatawag na reduced offer. But the balloting, the secret balloting shall be conducted by the National Conciliation and Mediation Board. Yung improved offer balloting naman, in case of a strike, there was an improved offer made by the employer. And the improved offer was accepted by the union. So the employer now will open the gates of the returning workers. Di wala na yung dispute. So take note of this principle of improved offer balloting and the principle of reduced offer balloting. Maliwanag? Okay? Or shall we have a short break? 1 minute. Hindi, biro lang yon. Sige. Naiihina ako kasi. Pila ron sa labas eh. Nakapila, no? Sa Singapore at saka sa Malaysia, hindi na pumipila. Doon na lang umiihi. May dalang ano? Wiwi pouch. Lalo pag traffic, naka-wiwi pouch sila. Paano yung pababae? Hintayin natin yung mga babae kasi mahaba yung pila kanina eh. All right, let's start. Now we'll take up, so we are through with these types of labor law, which I discussed pertinent areas of the bar already. So listen very carefully, okay? Now, we will now go to other areas like the sources of labor law. One of the sources of labor law is, of course, the Constitution. Aside from the omnipotent powers of the state, such as police power, which is an all-embracing power, and this is also important in the sense that, incidentally, the basis of police power is also the basis of the principle of social justice. You know this already. And we have also this principle of eminent domain, which has grown up to another principle under Article 12, Section 6. Article 12 of the Constitution, Section 6. Ano yun? The principle of distributive justice. Hindi pa binigay sa baryan. All right? And also, power of taxation, no. Of course, So we have police power, eminent domain. All right. We have this constitution. Now, what are the pertinent areas of the constitution affecting labor? Of course, we have the preamble. In the preamble, there is a phrase there which is very important and affects labor. A government that shall promote the common good. Under the 1973 Constitution, the preamble provides for a government that shall promote the general welfare. Sabi ng iba, the General Welfare Clause. Under the 1987, it is the promotion of the Common Good Clause. That's correct. But you know, there was a violent change from, there is a violent departure from the old Constitution for the reason that, according to the 1996 Constitutional Commission, there is a need to replace general welfare with promotion of the common good, because when you talk of general welfare, it admits an exception. Sandali, papatayin ko lang tong cellphone ko. Parang vibrator kasi. Kikiliti ako, gumaganon eh. Alam niyo yung vibrator, ha? Alam na alam niyo. Okay. According to the 1996 Constitutional Commission, there is a need to replace general welfare with common good clause. Is for the reason that when you talk of general welfare, it admits an exception. So a law can be passed just to promote the interests of a certain sector of the society, said Blas Ople, the chairman of the Committee on Preamble of the 1986 Constitutional Commission. So, under the new clause of the 1987 Constitution, pwede ibigay ito sa political law. Under the new clause, promotion of the common good clause, it simply means promotion of the welfare of all the people. Yun ang ibig sabihin ng promotion of the common good clause. So if you were asked to define what is police power under the revolutionary concept, when you talk of police power, this is an enactment of wholesome and reasonable laws to promote the common good. To promote the common good in line with the dictate under the 1987 Constitution, the mandate of the Constitution. Okay? Thank you, pare ko, ha? Kasi para medyo gumanda ang pagsasalita natin. Kasi mahirap sumakit ang lalamunan. Marami nagkaka-cancel sa lalamunan. Isang kaibigan ko, nagka-cancel sa lalamunan, namatay. Inoperahan eh. Siyang abogado rin. Inoperahan, nakita, panay buhok. Kulot pa. O makinig kayo, huwag na yung tama na yung mga kulot-kulot na yan. No? Sandali. Wala asukal. Bear with my whim and caprice, ha? Alright, medyo mainit pa. Pwede na yan mamaya. Okay, listen. So we have this promotion of the common good. Of course, Article 1, no, that's not related with labor. Well, Article 2 is pregnant with provisions on labor, no? We have this promotion of the protection to labor clause, promotion of adequate social services in the field of education, health, housing, employment, and social security. We have the emancipation of the people from poverty clause, promotion of full employment clause, principle of social justice, or the social justice clause under Article 2, Section 10 of the Constitution. Free access to the courts, non-imprisonment for non-payment of debt or a poll tax. And we tried to discuss this. This is very important, and I will discuss right away the pertinent doctrines that are bar areas, okay? We have the protection to labor. You know, the protection to labor clause of the Constitution is heavily relied upon not only by labor bodies but also the Court of Appeals and the Supreme Court in deciding labor cases. Protection to labor. Every year, almost every year, binibigay ito sa bar. In what manner? What is protection to labor? Why is there a need to protect labor? What is protection to labor clause of the Constitution? Mga ganon. What is the declaration of policy in the labor code? Kaya dapat alam niyo yung policy, the declaration of policy in the labor code. Article 3. Ano yung Article 3? That is a verbatim copy of the 1973 Constitution on protection to labor. The state shall afford protection to labor, promote full employment and equality employment, ensure equal work opportunities regardless of sex, race, or creed, and regulate the relations between workers and employers. The state shall assure the rights of workers to self-organization, collective bargaining, security of tenure, and just and humane conditions of work. Okay. Why is there a need to protect labor? Pag binigay sa bar yan, simple lang. Sasabihin nyo, there is a need to protect labor because as between labor and capital, labor is helpless and weak because of its economic dependence upon capital. Every now and then, ang ginagamit ng Supreme Court, yung economic dependence of labor upon capital. Kaya, there is a need to protect labor. There is a need to provide additional benefits to labor. Why? Because labor, between the two factors of production, labor is economically dependent upon capital. Tandaan niyo yun. Economic dependence of labor upon capital. So what is the evil sought to be prevented by the protection to labor clause of the Constitution? The evil sought to be prevented, people, is what? If labor, which occupies the bulk of the population of the state, becomes disgruntled, disappointed, unemployed, these people will what? Will be easily what? We can easily change their, what we call their political ideologies. Change their political ideology into an ideology which is foreign to Filipino ideology. So what happens? They go up to the mountains, fight the government, fight the capitalist system, fight the existing governmental system of the Philippines. So what happens? There is what we call a revolution or civil war. Kaya sabi ng Supreme Court, Ang sabi ng Supreme Court, the evil sought to be prevented by the protection, by the principle of social justice is what? The imminent social and political disquietude that may result in a revolution or civil war. That is the evil sought to be prevented by the protection to labor clause of the Constitution and the principle of social justice. Do you follow? So you know now, this protection to labor and also this principle of social justice. The state shall afford protection to labor, promote full employment. How would you protect labor, by the way, people? By enactment of laws. Like what? Laws on providing a living wage. Uy, pwedeng ibigay sa bar. What is the distinction between a minimum wage and a living wage? Look at me. A minimum wage provides a demarcation line. Demarcation line to. This is a demarcation line or an imaginary line. The bottom line. The rock bottom. Yan naman ginagamit ng Supreme Court. Rock bottom, bottom line, imaginary line. So that wages may not fall. You cannot bargain on wages below the minimum, but you can bargain wages above the minimum. Do you follow? So what is the purpose of the minimum wage law? So that wages may not fall from the minimum as provided by law. Maliwanag. Maliwanag. Ako na sumagot. Hindi kayo sumasagot eh. Nakuha ninyo. Now, binigay sa bar. What is living wage? Pag binigay sa bar yan, living wage. Diyan makikita kung sino Bartap Natcher. Kasi wala sa libro yung iba. But I discussed this in my book. What is a living wage? Well, according to my good friend, he said, living wage is not a mere subsistence wage, but it is a wage that provides the worker and his family to live in reasonable comfort. Tandaan nyo, reasonable comfort. And if the worker and his family can live in reasonable comfort, then it simply means that the worker and his family enjoy a decent standard of living. They enjoy the basic necessities of life. Yan ang ibig sabihin yan. Tandaan nyo yan. Okay, now, promotion of full employment. What is full employment? Halimbawa, binigay sa bar. What is full employment? Full employment simply means that the worker can find work under the prevailing rates of pay without any undue difficulty. Mamaya itinanong sa bar, what is full employment? 1.5%. Pag mga ganyan, 1.5% yan. Explain the concept of full employment, 1.5%. Hindi mo alam. Ano sabi ng bar reviewer sa mga bar candidates? Use your common sense. You have common, no sense. Wala rin. Use your common sense. What is full employment? Full employment simply means that a worker can find work under the prevailing rates of pay without any undue difficulty. Take note of that. In other words, simply stated, when you talk about full employment, there are more job openings than job applicants. Yan ang ibig sabihin ng full employment. Bakit ko tinitake up to? Kasi sa preliminary considerations, sa general principles and concepts, pati hanggang Article 13 ng Constitution, at saka yung Civil Code provisions, every year nagbibigay sa baryan. In my case, I gave one of the constitutional rights under Article 13, the principle of co-determination, the principle of shared responsibility in 2008. It was resounded by Justice Natura last year. Yung principles na yan. Under Article 13. Kaya sabi ko sa mga bar candidates last year here, memorize Article 13 on constitutional rights of a worker. Hanggang 4, mag-memorize kayo. Hanggang 4 nga binigay. Hanggang 4 binigay. Now, so memorize that. Article 13. No. So we have this promotion of full employment and equality, ensure equal work opportunities regardless of sex, race, etc. Now, we have this promotion of adequate social services. What are these social services provided for under the Constitution, mandated by the Constitution? Adequate social services in the field of education, health, housing, employment, and social security. Now, question. Ito bang adequate social services under the Constitution an extension of the principle of social justice? Yes. That is also an extension of the principle of social justice. So take note of this principle of social justice. Now, another. In the case of emancipation of the people from poverty. What is poverty? What is a labor law concept known as poverty? Explain. 1% o 1.5%. Hindi nyo alam. Oh, it's simple. Sasabihin mo, ilalagay mo pa. Oh, it's simple. Poverty. All of us are under the poverty line. Ganon answer mo. Kaya nung binigay namin yung 2008 bar, yung sa weight requirement, yung obesity sa 2008, mayroon hindi consonant yung answer. O imagine, if he is very fat, he cannot easily move along the aisle because the aisle of an airplane is very narrow. Wow! Very narrow. My God. Okay, let's continue. Alam niyo, nung nag-check ako, tumatawa ako sa sarili ko, kumisan. Merong ang penmanship, dapa. Nakadapa yung penmanship. Hindi mo na mabasa. Kaya pag babasahin mo, nakaganyan ka rin. Kasi nakadapa eh. Imagine, you have to decipher that. May nag-answer, Tagalog pa. Ang jurisdiksyon ng labor arbiter ay mga sumusunod. Mga ganun. Oh my God naman. Sari-sari. Oh my God, sabi ko. Lord, ba't ba ganito? Pero, I'm still fair enough. I passed almost 47%. Ang mandate sa akin ng bar chairman, hanggang mga 18% lang. Inunahan ko si Justice Tinga. Di nung natapos na ako, imposibleng pababalikin niya pa ako ron para mag-recheck. Hindi na ako nag-recheck. Ang huling nagpase si Justice Bersamin. Siya na-orderan. Huwag kang magpapasa ng marami. Patay. Kaya yung pumasa, 72.5 up to 74.99, halos lahat doon. Ako ang nagpapasa because of my grades given them. Kaya masaswerte yung mga abogado na yun. Pero hanggang ngayon, wala pa ako nakikita nagpapasalamat sa akin. Alright, let's continue. Another. So we have this, what's poverty, no? You know, when you talk of poverty, this simply means, this is a 4-word definition. Missing, much, M-U-C-H, in, I-N, life, L-I-F-E. Missing much in life. Ano ibig sabihin nun? That the worker and his family do not enjoy a standard of living. Yan ang ibig sabihin nun. Yang missing much in life, poverty. So if you are on a poverty line, you miss much in life. You do not enjoy the basic necessities of life. Another, we have this principle of social justice. Oh, this is a very important area now. What is this social justice? You should know the definition given out by Justice Laurel in Kalalang versus Williams when he said through his illuminating pen, that social justice is neither communism. Dapat alam niyo ito. Nor communism, nor despotism, nor anarchy, but the humanization of laws and the equalization of the social and economic forces of the state, so that justice in its rational and objectively secular conception may at least be approximated. Period. Social justice means the promotion of the welfare of all the people, the adoption by the government of measures, calculated to ensure the economic stability of all the component elements of the society, to the maintenance of a proper economic and social equilibrium in the interrelations of the members of the community constitutionally, to the adoption of measures legally justifiable or extra-constitutionally on the basis of the powers underlying the existence of all governments on the time-honored principle of salus populi es suprema lex. The same principles in police power. Take note that in social justice, there are two maxims that are the basis of this principle. Perhaps you still know this principle of utere ut alienum non laedas. Ano? Sic utere ut alienum non laedas. Ano yan? Alam niyo ba yon? So use your own as not to endure that of another. Sic utere ut alienum non laedas. So use your own as not to endure that of another. If you have your right, assert your right with due regard to the rights of other people. If you have your right, exercise your right without impairing the rights of other people. You have the obligation to protect the rights of other people under this principle of sic utere ut alienum non laedas. You cannot, sabi ng Supreme Court, you cannot hide from the mantle of social justice if indeed you are impairing the rights of other people. I'll give you a concrete example. Gaya nung nagbabatuhan ng mga squatters doon sa New Manila ba yun? New Manila? Oh. Hindi naman sila may-ari nun eh. Sino may-ari nun? Galit na ako. Sino may-ari nun? Yung landowner mismo. By the time that they were evicted out, they carry placards. We are protected by social justice. Ano sabi ng Supreme Court? That is a misplaced social justice. That is a misplaced social justice because in invoking social justice, in effect, they have impaired the right of other people. In effect, there is an injustice committed. Kaya ano sabi ng Supreme Court in one case? If you are going to invoke social justice, you invoke social justice with your clean hands. Tandaan niyo yan. So the Supreme Court said that social justice is never a refuge of scoundrels, neither a refuge of nincompoops. But social justice is a license to do what is right and never wrong, in accord with what principle? Sic utere, tuu, ut alienum, non laedas. Lately, this was also applied by the Supreme Court in one case. They have already abandoned this Hino case. There was a complete turnaround by the Supreme Court on Hino. In 2008, we have this case of Torres versus NLRC. And it was confirmed, reiterated, in the case of Garcia versus Paul regarding what? Wages that have been previously paid to a worker who was reinstated in the payroll upon finality, where there was finding of legal dismissal, the employer is not entitled for any refund or reimbursement of the salaries paid to the worker. Because anong sinabi ng Supreme Court? Social justice is superior over a civil law doctrine on unjust enrichment. Pwedeng ibigay ito this year. Ano sabi ng Supreme Court? Mas superior ang social justice as against a civil law doctrine of unjust enrichment. Kaya ngayon, sabi ng Supreme Court sa hinu-hino, dapat ibalik, mag-refund ang employee who was reinstated in the payroll. Sabi ng Supreme Court ngayon, lately, January 2009, adopting the doctrine laid down in Torres versus NLRC 2008 case. Ano sabi ng Supreme Court? Hindi na kailangan magbayad pa. Well. Sabi ng Supreme Court nga in other cases, it does not mean that we have committed a mistake in pronouncing this judgment, this doctrine, but there is a need to revisit the doctrine. Oy. Hindi i-admit na Supreme Court nagkamali. Ano sabi? There is a need to revisit the doctrine. Pag nagkamali ka sa policy making mo, there should be a fine-tuning. Fine-tuning lang yun. Fine-tuning. Di ba yung unang executive order, fine-tuning daw dapat. Di ba, no? Are they not man enough to say that we have committed a mistake? Kayo na bahala magtanong nun. O alam niyo na, pwede ibigay yung social justice in relation to unjust enrichment. Ano ang mas superior? Social justice. Galing, no? Tingnan nyo. You're learning now. All right, let's continue further. So we have this principle of social justice people, no? Another, free access to the courts. That is an extension of social justice also. Another, we have this non-imprisonment for non-payment of a debt. Is this a social justice provision also? Yes. Sabi ng Supreme Court ganito, the rich can incur debts. The poor likewise can incur debts. The rich can easily pay. The poor can hardly pay. So why punish the poor person because of his poverty? Pag binigay sa bariyan, sabihin nyo, the rich can incur that. The poor can likewise incur that. The rich can easily pay. The poor could hardly pay. So why punish the poor because of his poverty? Pag nag-issue ng check, he is being imprisoned not because of his poverty, but because for the issuance of a bounce check which is malum prohibitum. Okay. Alam niyo, ano ba itong nakuha kong karir ko sa buhay ko? Ang bigat nito. 1 hour to 1 p.m. up to 8 o'clock. 9 o'clock, no? Ang bigat. Imagine nag-iinit na yung bayag ko rito sa Alright, let's continue. Let's now go to the real McCoy, Article 3 of the Constitution. Makinig kayong mabuti dito kasi i-discuss ko ng gusto itong law on dismissal. And I will try my best na hindi pwedeng lumusot ang bar examiner ninyo sa law on dismissal. Makinig lang kayo. Okay? That's a covenant, ha? Babalik kayo. Ay, hindi na kayo. Paano yung wala rito? Okay lang, no? Okay lang. Talagang ganyan. Imagine, palagay ko yung spirito naman nila nandito Nandito siguro yung spirito nila. Sayang. They pay for it. Tapos, sayang. Alright, let's continue. We have Article 3. What is the pertinent area there? The due process clause of the Constitution. No person shall be deprived of his life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the law, known as the due process. No person shall be deprived of his life, liberty, property. Settled by the Supreme Court already that the right to labor is property. So the right to labor is property within the mantle of constitutional protection. Take note of that, people. Very important. All right. So no one shall be deprived of his right to labor with his property without due process of law. Okay. Wow. All right. Due process as observed in judicial proceedings, especially in criminal, what is the quantum of proof? Proof beyond reasonable doubt. In labor proceedings, which is an administrative proceeding, presentation of substantial evidence. You know this already, okay? Now, so, no person shall be deprived, no person or no employee shall be dismissed except for causes provided by law. In other words, there are two aspects of due process as far as dismissal is concerned. Okay? Tingnan nyo. Utusan nyo ako rito. Due process. We have the substantive. We have the procedural. Due process. Ito yung aspects or facets. Under substantive, no employee. Under substantive, no employee shall be dismissed except for causes provided by law, but the substantive aspect refers to the legality or illegality of the act of dismissal. Tandaan nyo, act. Sa procedural, refers to the legality, illegality of the manner of dismissal. Under the substantive aspect, no employee shall be dismissed except for causes provided by law. What are the causes? Maraming causes, but general, there are two. We have the just and the authorized or the statutory. Ang tawag is statutory clause. Cause. Procedural, we have the two notice rule, and we have hearing. But sometimes hearing is dispensed with because the Supreme Court said that what is important is that the employee is given the opportunity to be heard. It is enough that there was an explanation made, and on the basis of the explanation, the employer is not satisfied, walang hearing, sabi ng Supreme Court. In some cases, kahit walang hearing, the purpose of due process is that the persons or the parties are given the opportunity to be heard. All right. Under the first aspect or facet, no employee shall be dismissed except for causes. We have the just causes, authorized causes, causes for health reasons, di ba? Causes for health reasons, and resignation. Lately, sabi ng Supreme Court sa resignation, voluntary repatriation of a seaman is tantamount to resignation. Baka magkamali kayo, baka ibigay sa barto. Voluntary repatriation of a seaman is or amounts to voluntary resignation. All right, listen very carefully. Okay. Take note, people, that you can have a fully understanding, shall I say, of the law on dismissal if you know what is a just cause and you know what is an unauthorized cause. In the case of Jaka Food versus Pakot, the Supreme Court had the occasion to define the distinctions between the two. Number one, in a just cause dismissal, the dismissal process is initiated by the employee. On the other hand, in an authorized cause dismissal, the dismissal process is initiated by the employer. Number two distinction. In a just cause dismissal, as a general rule, there is no payment of separation pay. On the other hand, in an authorized cause dismissal, the law mandates payment of separation pay. Number three, distinction. For non-compliance of the due process requirement in a just cause dismissal, the penalty imposed against the employer is payment of nominal damages, which is tempered. Baka hindi nyo alam yung spelling. Tempered. For non-compliance of the due process requirement in an authorized cause dismissal, the penalty imposed against the employer is also payment of nominal damages, which is stiffer. Ano yung stiffer? Malaki, matigas. Anong gusto niyo? Malaki o matigas o both? Stiffer. Stiffer. Okay? Alright, so those are the distinctions. Iisa-isahin natin to because these are all bar areas. I should advise you, you listen. Hindi ako nagbibiro. Every year, dito nagbibigay sa bar. Dito sa law on dismissal. If you know all the principles here, tapos yung pagpapile ng illegal dismissal case from the labor arbiter hanggang sa Supreme Court, yung procedural requirements niyan, kayang-kaya nyo ang sagot din yan, kahit ano. Kaya makinig kayo. Okay. We have this first distinction in a just cause dismissal. The dismissal process is initiated by the employee. What are the just causes initiated by the employee? Not by the employer. Akala niyo pag dismissal initiated by the employer? No! Initiated by the employee? Initiated by the employer. Initiated by the employee. What are the just causes? Serious misconduct. Willful disobedience, fraud, willful breach of trust, gross and habitual neglect of duty. Ano pa? Commission of a criminal offense against the employer and members of family, including managerial employees. Analogous causes. Kasama rin dyan yung abandonment initiated by the employee. Ano pa? Resignation is also initiated by the employee. Tandaan nyo uli, voluntary representation. Yung voluntary representation amounts to voluntary resignation. Yun ay applied sa seaman. You know a seaman? Alam nyo ang seaman? O seamen? Ang alam nyo, seamen. Seamen or seafarers. Di ba? Seamen. Yan naman may mga bulitas. Mga seamen, may mga bulitas. Kaya mayayabang yung mga seamen eh. Di ba? Kala mo na nakaano lang sa barko. Nakasakay lang sa barko kahit na nandito na sa patag eh. Kala mo na inuuga pa rin ng alon, gumagano na. Alam niyo ba na yung joke na yun? Ay, hindi. Sige ha. Maiksi lang ha, kasi para mawala yung Merong isang seaman pagdating dito. I have 2 seamen. Brothers. Yung isa mayabang. Yung isa wala na, nag-jump ship. Yung isa naman, mayabang din. Mga inaanak ko sa kasal, panay seamen. Kasi ako ang abogado ng isang manning agency dyan sa Top Avenue. Ako palagi, ako ang external counsel. Ako ang kinukuha ang ninong. Meron akong, inaanak sa kasal, ang yabang. Pagdating, uminom sila. Doon, taga Talisay, Batangas. Nagiinuman sila, inimbitahan yung mga taga Talisay, doon sa baryo nila. Sabing ganun. Masarap maging seaman, bakit naman masarap maging seaman, tignan mo, pag ikaw ay seaman, lahat matitikman mo. Bakit? Sino ba mga natikman mo? Sa Latin America, maraming babae. Nako, ang lalaki pa. Tatang. Habang nagkukwento yung seaman, pag ganun-ganun. Di yung mga matatanda ron sa baryo, barangay, sinusundan din siya, ganun. Inabisit yung isang taga-barangay. Ano sabi mo? Masarap na maging seaman? Oo. Bakit ganyan pa-ogoy-ogoy ka? Alam mo, 5 taon ako sa barko. Bakit pa ganyan-ganyan ka? Kala ko'y nasa alon pa ako. Kala niya raw, nasa alon pa siya. Kaya pag nagsasalita siya, pag ganon. Sabi ng matanda, tarantado kang bata ka. Bakit putang? Ako'y 30 years na gumaganon. Hindi naman ako pag ganon-ganon. Ba't 30 years na ganon? Ba't hindi raw siya pag ganon-ganon? Yung seaman, 5 years lang, gaganon-ganon na. Si 30 years na gumaganon. Hindi naman pag ganon-ganon. Nawala na yung antok niya, no? Okay, let's continue. Serious misconduct. Serious misconduct, according to the Supreme Court, is a wrongful conduct. It is an improper conduct that has been committed in an aggravated or serious manner. Yan ang ginamit. Aggravated or serious manner. Kaya pag the offense committed is serious misconduct, at saka ano pa? Offenses reflective of moral character, walang separation pay. Take note of that. Now, what are the offenses that may be treated as serious misconduct? Well, in a katina of cases decided by the Supreme Court, what are these cases? Cases involving sexual harassment, fighting in company premises, thievery, pagnanakaw, theft, gambling in company premises, immorality, and analogous causes. Ano sabi ng Supreme Court sa sexual harassment? Sa sexual harassment, tandaan nyo, sigurado magbibigay dito. You should know the requirements for an act of sexual harassment. There is a superior here who wields moral ascendancy or moral dominance. The victim is either a student, a trainee, or a worker. Kaya nga, training-related environment, work-related environment, education-related environment. Ano pa? The victim is placed in an intimidating, hostile, offensive environment. Iho. Halimbawa, look at me. Ganito yan. Para hindi nyo makalimutan, look at me. Para pag halimbawa binigay sa baryan, nakikita nyo yung mukha ko si Atty. Pokis. Ganito yan. Halimbawa, yung superior pagpasok ng yung girl, yung hindi student, empleyado. Hi, sweetheart. Oh, bango-bango mo. Pangalawang morning, pumasok uli. Sweetheart, alam mo, ang ganda ng hita mo, ang sarap papakin. Naririnig ng mga co-workers, co-employees. Pangatlong morning, alam mo, sweetheart, nung isang araw pa, atat na atat ako sa iyo. No touch, no touch. Touch is not an important element in sexual harassment. Take note of that. Is there sexual harassment? Yes. Why? Because the victim, yung iha, yung sweetheart niya, patawagin na lang nating iha para iha, iho. Hindi nyo na makakalimutan. Ang pangalan ng biktima, iha. O ya, iha, iho. The iha was placed in an intimidating, hostile, offensive environment. Now, under such circumstances, nag-resign si iha, can she file a case of constructive dismissal? Sasabihin nyo, yes, period. Iha can file a case of constructive dismissal because of the utterances of the superior, which she cannot stomach anymore. Usually, mga ganyan ang sagot ninyo. Yari kayo. Because she cannot stomach it anymore. Mga ganon. Oh my God. Simple lang ang pagpasasabar. Ganito. I'm guiding you. Yes, Iha can file a case of constructive dismissal because continued employment has become impossible, unreasonable, unlikely, and unbearable under such circumstances because she is placed in an intimidating, hostile, offensive environment. Kaya dapat alam niyo yung definition ng constructive dismissal. Ano ba yung constructive dismissal? Continued employment has become impossible, unreasonable, unlikely, or unbearable. Mamili na kayo ron. Hindi yung babanatan nyo kaagad. I'll give you a concrete example. The workers were assigned living quarters. Living quarters. Yung living quarters, dirty comfort room. There are several rats running around in the premises. Hindi makatulog. No ventilation. Under such circumstances, can the workers file a case of constructive dismissal? Sasabihin nyo, yes. They can file a case of constructive dismissal because imagine there are several rats running around in the area. Oh my God, the usual answer. Sasabihin nyo, yes, they can file a case of constructive dismissal because continued employment has become impossible, unreasonable, unlikely, and unbearable under such circumstances. Period. Can you go wrong? Of course not. You cannot go wrong. Shall we have a short break again? Naiihi na naman ako eh. Dahil sa kape. Ng lahat. Sana maglagay na lang ng host diretso ron, no? Para walang problema, nandito lang tayo. Hindi naman pwede, no? Pila na naman sa labas eh, pila. Tapos na ba si Dean Aligada dito? Kahit matanda na yun, malakas pa rin, ano? Painumin mo lang ng Coke. Si Coke yun eh, Coke. Sa labor law, sino natapos na rito sa inyo? Si Oswi. Oswald Lorenzo. Sino pa? Wala pa? Sige, makinig kayo. Wala, ang dami. Okay. So, serious misconduct, no? What are the other forms of serious misconduct? In one case, the Supreme Court said that gambling in company premises is a form of serious misconduct because of its pernicious effects upon society. Ang ginamit ng Supreme Court, pernicious effects. Again, fighting in company premises is also a form of serious misconduct, where the Supreme Court said that it is a form of serious misconduct because it disturbs the peace of the workplace. Also, theft is a form of serious misconduct because it is an act of dishonesty. But take note that in theft, although it's a form of serious misconduct, the Supreme Court ruled that in theft, you have to consider the amount of the property taken. If the amount of the property taken is negligible, ano ginamit ng Supreme Court? Negligible. Then, dismissal is too harsh a penalty. Again, gamitin nyo yan. Pag binigay sa baryan, maraming gumamit sa akin yan noong 2008. Sabi ko, kasi yan ang sinasabi ko palagi, dismissal is too harsh a penalty. Ay, sinabi nila, dismissal is too harsh a penalty. Sabi ko, ay, estudyante ko to, hindi dapat bumagsak to. Kaya nakuha lang 60, binigyan ko 75. Ganon. Dismissal is too harsh a penalty. In other words, in theft, the Supreme Court ruled that the amount of the property taken is negligible. So if the amount of the property taken is minimal, sabi ng Supreme Court, dismissal is too harsh a penalty. In other words, he is still entitled to reinstatement but without back wages. There is no back wages in order not to give premium to an act of dishonesty. Yan ang sinabi ng Supreme Court. In order not to give premium to an act of dishonesty. Maliwanag? Okay. I'll give you a concrete example. Alam niyo ba yung, halimbawa, baker. Ano yung baker sa Tagalog? Panadero. O yung panadero has been employed by Gardenia for 15 years. Ano pa ginagawa ng panadero? Nagmamasa. Marunong ka bang magmasa? Hindi ka nagmamasa? Have you not experienced masa? Hindi. Ilang taon ka na ba? Hindi pa marunong magmasa. 25 ka na ba o 26? 28? Sige. Hindi marunong magmasa. Okay, tagamasa ng pandesal. One time, the panadero was caught stealing 15 pieces of pandesal. Imagine, 15 pieces. He has been in the service, yung panadero, 15 years. Tapos, yung ninakaw niya, 15 pieces of pandesal. Hindi niyo makakalimutan yan. Ang importante dito, yung principle. Length of service, 15 years. Ano ninakaw? 15 pieces. How much? Siguro mas 75 pesos. Is dismissal proper? Sabi ng Supreme Court, dismissal is too harsh a penalty. So what is the rule here? You apply the proportionality rule. Proportionality rule. The penalty to be imposed must be commensurate to the degree of offense committed, otherwise known as the doctrine of commensurate penalty. Tandaan niyo yan, ha? So, considering his length of service, so you have to apply here the factor of length of service and the amount of the property taken. Disproportionate yan. Under the, tawag doon. All of you. Oh, alam niyo yan. Alam niyo na. Proportionality rule. So take note, the amount of the property taken. But if the amount of the property taken is not negligible, it is what we call a huge amount of money lost in the coffers of the company. I'll give you a concrete example. Dito sa kaso nato, talo ko. From the labor arbiters level until it reaches the highest court, talo. Bakit? Isang assistant branch manager ng bangko na kliyente ko, kinuha niya pera, almost 300,000. Ginamit niya pag-amortize ng pagbabayad ng bahay ng kanyang kapatid. After 2 days, binalik niya. Audit finding was conducted, yari na siya. So she was dismissed. We filed a case of illegal dismissal, 30 years in service already, almost 30 years. Binanat ko length of service and under the principle of compassionate justice, on the broader ground of substantial justice, principle of social justice, lahat ng justice. Wala, talo pa rin. It reached the Supreme Court. Ano sabi ng Supreme Court? Kahit na sinabi kong retirable na yan, 30 years na yan. Sabi ng Supreme Court, length of service is overshadowed by the gravity of the offense. Ilagay nyo yan. Mamaya ibigay sa pariyan. Length of service is overshadowed by the gravity of the offense. Nakuha niya. Maliwanag. So take note. There are certain factors to be considered in determining the penalty of dismissal. Gaya ng length of service, gravity of the offense, employment position, nature of the business, totality of infractions, vis-a-vis first offense rule. Usually, if it is your first offense, dismissal is too harsh a penalty. But it is a commission of different offenses. Does the employer waive its right to dismiss an employee despite previous offenses? There were no penalties imposed, the Supreme Court said. If there are no penalties imposed against previous offenses, it's not a waiver on the part of the employer to dismiss an employee. Because under the totality of infraction principle, still an employee can be dismissed for a just cause. But if it is a first offense, the first offense rule applies because dismissal is too harsh a penalty considering that it is his first offense. That is considering that if the offense committed is not so grave or aggravated in nature. Maliwanag? Okay. Kaya tandaan niyo yung nature of the offense, gravity of the offense. yung nature of the position. You have also to consider the nature of the position. If you are a managerial employee or a rank and file employee. In the application of the principle of trust and confidence, mere finding of the basis of loss of trust against a managerial employee is sufficient for a just cause dismissal of a managerial employee. But a different rule applies in the case of rank and file employees. Why? Because managerial employees are the alter ego, the extension of the management. In fact, from the point of view of the rank and file employees, the managerial employees are the employer. Tandaan niyo yan. Now, ano pa? Nature of the business. In the case of the nature of the business, if there is a violation of company rule or regulation, say for instance, dito, no smoking rule. Okay, no smoking. One of the employees of San Sebastian was caught smoking inside inside school premises. He was dismissed. It was his first offense. Anong magiging, is dismissal proper? Sabihin nyo, no. Period. Dismissal is not proper. Or dismissal is too harsh a penalty. It being his first offense. Under the first offense rule. Nakuha niya? O kaya, it was his first offense. It was his first offense in his 15 years of service. Kasi i-apply nyo ngayon yung length of service. Maliwanag? Okay. So, an employee was dismissed for smoking. Are there combustible materials that are stored here in the school premises? Wala. Combustible ba yung mga yan? Hindi Yung mga chairs. Unless na sinunog, gaya nung ginawa ng mga estudyante sa PUP, sinunog yung mga Now, halimbawa, violation of company rule regulation, no smoking. An employee or a worker of PNOC. He was assigned to check the bulbs, the bulbs of gas depots at Pandacan, Manila. While he's checking upon the bulbs, he was smoking. Wow, sarap. He was caught smoking. When he was interrogated, sabi niya, "Oh, you cannot dismiss me, mister. I'm not smoking. You caught me holding a cigarette, but the cigarette is unlighted. If you are the laborist arbiter, will you still dismiss him?" Ano ba kayo? You have to consider the nature of the business. Where combustible materials are stored, whether or not the cigarette is lighted, a slight mistake may or might raise down the entire establishment to the whole ground. So, the imminence of fire will justify dismissal of an employee despite the fact that it is unlighted. In other words, in areas where combustible materials are stored, there must be a strict implementation enforcement of safety measures. That is an old case. Pero take note, bar examiners are fond of shall we say, resurrecting old cases. Have you experienced resurrecting? Resurrecting a dead thing. Resurrection is the order of the day. Tandaan niyo, resurrecting. Ano malay niyo, ibigay sa baryan. But when we were required by Justice Tinga to prepare a question, you prepare a question on the basis of caudal provisions. Yung caudal provisions, marami ring involved na cases. The cases din yun. Kaya kayo maniwala dyan. Sabi nung 2008, excluded Book 4. Bakit nagbigay sa Book 4? Kayo, expect the unexpected in the bar. Ganun na lang, ha? Kaya tandaan niyo yung sexual harassment, no? Ayan. Ano pa? So, this is serious misconduct. It's a wrongful conduct, but this is committed in an aggravated or serious manner. All right, another willful disobedience. There is a perverse attitude to obey reasonable company rules and regulations. The law requires that the rule and regulation is fair and reasonable. So, there is a company rule and regulation, fair and reasonable, issued. This was violated, and the employee performs job that is related to the fair and reasonable company rule or regulation. However, if it is an isolated offense, you will apply what rule? First offense rule. Unless if the first offense resulted in several big losses to the company, where even if it is first offense, dismissal is proper under the circumstances. So, if you are given these facts, people, you have to read and reread the facts of the problem and apply the pertinent principles I have given you. Tandaan niyo yan. Now, in willful disobedience, say for instance, there is a rule regulation that all company drivers should procure a company, what do you call this? An approval before they can take out a company vehicle, no? A trip ticket, halimbawa, trip ticket. Walang trip ticket. Every now and then, it takes out company vehicle. Mercedes-Benz, Volvo, Cadillac, BMW, etc. Just to, visit his girlfriend, and have a quickie in the quickie along Santa Mesa. Quickie, 179, 174, 250, garage room, etc. Imagine, nagkasala pa tuloy dahil dyan sa mga quickie na yan. Pero meron akong discount card dyan. Huwag kayong mag-hotel din sa Sogo, ang baho. May nagbigay sa akin ng discount card. So, dinala ko misis ko, siyempre. Sogo, baho. Mas maganda yung ganito. Alright, listen. Willful disobedience, fraud, insubordination. Willful disobedience is also insubordination. Okay. Gross and habitual neglect of duty. Sabi ng Supreme Court, it should be gross, at the same time, habitual. But in other cases, the Supreme Court said, although it is not habitual, provided it is gross, it is a just cause for termination. So which is which now? In one case, sabi ng Supreme Court, it must be habitual. But you have to consider again the amount of the property lost. Halimbawa, nagdi-deliver ng McDo. Oh. Pag-deliver, sinusundan na pala ng mga carnappers. O hijackers, shall we say. They have a ban, a closed ban. When the delivery boy stopped to unload the pizza or the McDo hamburger, the robbers, the carnappers got down from the van, took the whole yung motorcycle together with the pizza or McDo still intact inside. So nilagay nila sa loob, they closed the van. When the delivery boy came out from the house, wala na yung niya. Halimbawa, 100,000. Each first offense, not habitual. Is dismissal proper? Sabi ng Supreme Court, proper. Considering the loss, shall I say loss, L-O-S-S. Considering the amount of the property lost, L-O-S-T. 100,000, although not habitual. But as a general rule, it must not only be gross, but it is habitual. So, in the case of absences, sabi ng Supreme Court, it must be prolonged, unauthorized absences for an employee to be dismissed for gross and habitual neglect of duty. Well, in the case of willful breach of trust, there are two types of employees who are liable under this area. First, managerial employees. Take note of the fiduciary relationship between the employer and managerial employees. Trust and confidence. So I told you a while ago, mere finding a basis of loss of trust and confidence, they can be dismissed. Why? Because of trust and confidence. Second type of employees under trust and confidence, rank and file employees who are assigned to protect company money and property. Gaya nandyan yung teller, property officer, accountant, etc., and so on and so forth. Sandali lang. Pampatigas ng laman to eh. Sabi yung pants, pare. Di ba na? Nandyan na eh. Nawala tuloy ako. Nasaan na ako? Trust and confidence. Protection of company property and money. Rank and file. Gaya ng property officer, teller, di ba? Ano pa? Cashier, mga ganon, no? Ayan. Gross and habitual neglect of duty, commission of a criminal offense against the employer, members of family, including managerial employees. And in abandonment. In abandonment, there is a willful intention not to return. Willful. Precipitate, willful intention not to return. And this shall be shown by overt acts. There must be overt acts. Now, if an employee was dismissed for abandonment but he filed a case of illegal dismissal, sabi ng Supreme Court, the fact that he filed a case of illegal dismissal negates an act of abandonment. sabi ng Supreme Court. No? Of course, in abandonment, take note that the two-notice rule shall still apply. Di ba? Two-notice rule and hearing. Kailangan pa ba hearing? Ano ba kayo? Sino ihihiring nyo riyan? Wala yung tao. Kaya tandaan nyo. Alam niyo, pag sira ulong barig sa amin, papasok sa utak niya ito, nga, no, abandonment, wala na yung tao. Tatanungin ko kung may hearing. Di patay kayo. The law provides that there must be a tone that shall comply with the two-notice rule and hearing. I submit. Huwag na kayong magsasubmit. Tandaan nyo, pag sinabi nyo, I distinguish, I submit, it depends. Sira na kayo kagad. Pag nakita ko, it depends, I submit, sabi ko, hindi niya alam. Hindi niya alam ang answer nito. Kalahati kagad, may doubt. Kaya, I submit. No. Walang I submit. It depends. No. You can answer in such a way that both is correct. I'll give you a concrete example. Are service charges part of wages? Pwedeng yes, pwedeng no. Yes, period. Service charges are part of wages when they are abolished because they are integrated into the wages, period. No. Period. Service charges are not part of wages. However, when they are abolished, they are deemed integrated into the wages. It depends upon your legal anchor, your legal essay. Do you follow? That's why the instruction to us by Justice Tinga, whether yes or no, tama yung answer niya, tama yung legal anchor niya, legal basis niya, bigyan ng points, bigyan ng credit. So I'm telling you, when you come out of the bar area, ano answer mo? No, ako yes. Naku, mali ako. Patay na. Mali ako. Di ba yes, no? Ako, basta nung ako. What a petty actuation. That should not be the case. Be firm in your legal basis, be firm in your legal anchor, and you will pass the bar. Tandaan niyo yan. Okay? All right, let's continue. So, abandonment. Two-notice rule, you should provide him, send him the first notice. The first notice is the formal charges. Ano yung formal charges? Abandonment. That you have abandoned your position and explained within 48 hours or 72 hours. Otherwise, you will be dismissed. Yon. Hindi pa rin nag-report back for work. Another notice, notice of dismissal. Since you have not reported back for work, the employer decided to dismiss you. Yun, two-notice rule. Without hearing. Siyempre, walang hearing, wala eh. Inabandon na nga. Paano mo tatawagan? Nag-abandon na nga eh. Magkakaroon pa ba ng hearing? Wala na. Ano sabi ng Supreme Court? Incongruous. Tandaan niyo. Incongruous. Obstinate. Naiintindihan niyo ba yung mga obstinate, incongruous na yan? Kaya nga ako, nilalagay ko, pag sa libro, instead na obstinate, nilalagay ko stubborn. No? Kasi yun ang ibig sabihin, obstinate, stubborn. Mas maintindihan. Alam niya, katina. Katina of cases. Inter alia. Alright, let's continue further. Ano pa? So, just causes. We will now go to another area of the bar. Every year, nagbibigay dito. Iisa-isahin ko to. But before I forget, meron pang initiated by the employee in resignation, by the way. In resignation, people the resignation must be accepted by the employer. To be valid, resignation must be accepted. Once accepted, it cannot be withdrawn. If it is not yet accepted, it can be withdrawn. Now, it was already accepted. You still want to continue with the employer. Can the employer place you on a probationary basis? Yes. Kasi under the first employer-employee relationship has already ceased. Tapos na. Pwede. So you are now employed on another employment provision, employment term and conditions. Pwedeng wala ka ng wala ng probationary employment. Automatically, you are a regular employee. Pwede yun. So, there must be an acceptance, people. Now, can we withdraw it before acceptance? Yes. What if, say, for instance, what you have tendered is a verbal resignation? Mr. Company, ayoko na. Nagre-resign na ako. What will be your proof now that he resigned voluntarily? You accept it in writing. As per your verbal resignation, we are, much to our regret, we are accepting your resignation, voluntary resignation. Please be guided accordingly, etc. That's your proof that indeed she resigned. Kasi verbal eh. Or the board accepted the resignation of an employee, as the case may be. Do you follow? So what is resignation? Take note that resignation as a general rule is a voluntary one, voluntary undertaking on the part of the employee. So what is resignation? Resignation is a voluntary act of an employee whose personal reasons cannot be sacrificed in favor of the exigency of the service. Wow. Hindi nyo nakuha? Personal, mas importante yung personal reasons vis-a-vis the exigency of the service. Kaya, personal reasons cannot be sacrificed in favor of the exigency of the service. Yan ang voluntary resignation. Now, question. If under certain conditions, you have resigned, although voluntarily, it can be treated as a forced or involuntary resignation. When you are compelled to act in such a way that you have no other means but to resign, to abandon, surrender your position, because the employer makes it hard for you to continue in your employment. That is forced resignation, involuntary resignation, which amounts to constructive dismissal. Treating you with insolence, disdain, insensible act. Bakit? Imagine, you were, say for instance, you were demoted in rank, you were demoted with a reduction in pay. Those are also indications of constructive dismissal. I'll give you a concrete example again. Here is a vice president, a lady vice president. She caught the ire of the company. She was assigned as the head of the legal department of the company. A non-lawyer at that, assigned as the head of the litigation department of the company. Oh, sabi ng mga lawyers, God naman, grabe naman, kung ako mahihiya ka naman, dapat mag-resign ka na. Imagine, under you are litigation lawyers, you are a non-lawyer. Pag ako magre-resign ako, sabi nung lady president, dapat mag-resign ako para akong rito, decorative employee, no? Nakakahiya, no? Kaya ano nangyari? Against her conscience, she resigned. With that amount to constructive dismissal? Yes. Yes. Because because continued employment has become impossible, unreasonable, unlikely, or unbearable under such circumstances, because she was assigned a position where she is not qualified or not competent. Ganon ang answer sa bar. Do you follow? Naintindihan niyo ba? Hindi. Ba't kayo natatakot sa akin? O sige, at ako'y magpapatigas muna ng laman-laman dito. Kasi binigyan ako ng Lipobitan D at saka Yakult. Sabi sa advertisement, sabi nung anak sa tatay niya, Daddy, mag-Yakult ka muna. Imagine, pinagsabihan yung ama, mag-Yakult ka muna. Ano bang klaseng advertisement yun? Mag-Yakult ka muna, sabi niya. Kayo ba nag-Yakult? Sige. Let's give them mga 2 minutes for them to enter the sanctum sanctorum. All right, we are now discussing these authorized causes or the statutory causes. Take note, people, that the following are the authorized causes. Introduction of labor-saving device known as automation. Number 2, retrenchment, otherwise known as downsizing. Economic meltdown. Number 3 is redundancy. Number 4 is disease. Number 5 is closure of business. Number 6, analogous causes. All right, in the case of introduction of labor-saving device, in order to promote more economy and greater efficiency, it is a management prerogative to replace its workers by machines. In other words, introduction of labor-saving device is a replacement of men by machines. in order to promote more economy and greater efficiency. Here, the employer is not on the verge of economic collapse, but the company indeed is actually gaining. Kasi hindi bibili ng mga machines yan to replace workers kung walang pera. So the employer here or the company is not on the verge of economic collapse. That is the reason why in introduction of labor-saving device known as automation, the payment of separation is full month pay for every year of service. In other words, in automation, it is a replacement of men by machines resulting in what we call a technological unemployment. O baka naintindihan nyo na ngayon kung ano yung automation na yan. Introduction of labor-saving device. Now, you might be asked on the requirements of automation. Number one. Ano yung number one? The compliance of two separate notice rule. Oh, look at me again. In just causes, we have the two notice rule. In authorized causes, we have the two separate notice rule. Two separate notice rule. That is the correct pronunciation. Two separate. Hindi separate, di ba? Ngayon alam niyo mga pronunciation. Dapat magiging abogado kayo, dapat yung mga advanced pronunciation, alam niyo. Separate. Yung dedicate. Hindi mo na maintindihan tuloy. Dedicate. Certificate. All right. So we have the two separate notice rule. Bakit two separate notices? 30-day notice to the dole, 30-day notice to the employees to be discharged or to be dismissed. Anong gusto nyo? To be dismissed or to be discharged? O mamili na kayo. Number two requirement, reasonable criteria. Binigay na to sa bar. Ito bang reasonable criteria mandated by law? They are not mandated by law. These are reasonable criteria crafted by the management. So what are these reasonable criteria? Perhaps based on the, shall we say, performance rating, employment position, or on the basis of length of service, such as the seniority rule. You may be asked in the bar, what is seniority? Seniority is the equity of an employee on his work based on length of service. It is the equity of the employee on his work based on length of service. Maliwanag, reasonable criteria. Number three, take note that you can pass the bar, you become lawyers because of this. Lahat ng gagawin nyo, it must be done in good faith. Gaya ng employer, it must be done in good faith. So, if the authorized cause embarked by the employer is not in good faith, in other words, the employer is in mala fide, then the employer is liable under the law. Why? Because if it is not done in good faith, the discharge of employee will amount to what? Or it will metamorphose it will metamorphose into a case of constructive dismissal. Tingnan nyo. Kaya alam nyo, tandaan nyo, lahat ng itong mga authorized causes na to, if they were done in bad faith, not done in good faith, they will metamorphose into a case of constructive dismissal. Again, may I remind you of the meaning of constructive dismissal. Because of the meaning of constructive dismissal, you will become a lawyer. And you will be called later on, attorney! O, tingnan nyo. Pag nasa, attorney! O, attorney na pala ako. Attorney. Tingnan nyo. O, kaya kung ano yung sinasabi ko rito sa inyo, sundin nyo. O, dapat alam yung mga definition na ganyan. Alright, listen. Ano pa? Aside from it must be done in good faith, there must be payment of separation pay. Since the company is not losing full month pay for every year of service, a fraction of 6-month employment is treated as 1 year. Puta, bumili ka na kaagad na naman ng lipobitan. Mamaya baka mahirap nito, mamaya baka hindi na lumambot ang kalaman ko niyan. Alam nyo, hindi ko mapahindian ng San Sebastian Law College of Law. Bakit? Kasi ang din dito, kasama ko yan, hindi pa kami abogado. Nung kami nagtuturo pa sa PCC noon, Philippine College of Commerce, kami nila Attorney Romy Makalintal. Si Dean Riano, si Willard, ang tawag namin doon si Jaworski. Tall, dark, and handsome . Ako naman tawag nila si Christopher De Leon, si Boyet. Sabi ko, hindi na pwede ngayon, malaki na yan . No? Pero we belong to that age, no? Si Romy Makalintal, he has excelled in election. Si Willard naman sa commercial and remedial. Tayo naman sa labor at political. Pwede na. No? Pero mahirap itong nakuha naming karir. Imagine, uupo ka dito ng 8 hours. Jingle lang ang pahinga. Mahirap nito. Sabi ko nga kay Willard, putsa, ano ba itong nangyari sa atin? Parang Willard, ako. Sabi niya, talagang ganyan, Padre. Yan ang napunta sa atin. Yan ang inassign ni Lord sa atin . Kaya, yun ang inassign sa akin, I have to help. I am here to help you. You know, incidental lang dito yung pera. Nagle-lecture nga ako, kuminsan wala . Pinagle-lecture ako kuminsan iniimbitahan ako mga estudyante. Ni ako pa bumibili ng mineral water ko . Imagine, talagang ganyan . Alright, let's continue. So take note of this introduction of labor saving device. Pero importante rito yung requirements, yung requirements. Pwede kayong banatan dyan sa requirements. Lacking some of the requirements will metamorphose into a case of constructive dismissal. Take note of that. Number 2, we have retrenchment. Ito ang paborito ng mga bugoy. Yung mga bugoy, gaya ko bugoy. Yan tinatawag ng mga paborito ng mga bar examiners itong area na ito, retrenchment. Of course, retrenchment is actually, the company is on the verge. Mamaya on the verge sa ilalagay nyo, BIRDS. May gali, one time, no? Ano ba yung mga napagbabasa ko noon? However, HAWEBER, yung B, not in victory, as in boy. However, HAWEBER, however, no, my God. Sabi, tingnan nyo. Here in retrenchment, the company is losing. But the law requires that it does not mean that the employer or this company is actually losing, because the losses may be anticipated. Kaya on the verge of economic collapse, or it has already collapsed, pwede yon. Or on the verge of economic collapse. Bakit? Sabi ng Supreme Court, even if the losses are anticipated, the employer should do something in order to arrest the impending economic catastrophe. Impending economic catastrophe. In other words, the purpose of retrenchment is to prevent further hemorrhaging of capital. Ano yung hemorrhage? Double R yan. Di ba? Hemorrhaging of capital. So the Supreme Court said that although the company is not actually losing, it can embark on a retrenchment program in order to prevent further hemorrhaging of capital. And in order to prevent an eventual economic catastrophe. Ganun yon. The employer, said the Supreme Court, should not wait for the time when the employer indeed, shall we say, incurred actual losses. Kahit pa walang actual losses, impending pa lang yan, anticipated pa lang yan, the employer has the management prerogative to embark on a retrenchment program. But before embarking on a retrenchment program, it shall first, what? Conduct certain measures in order to prevent it. Sabi ng Supreme Court, no? It should conduct first some measures in order to prevent it. Gaya ng halimbawa, forced leave o exhaustion of sick leave of absences sa mga employees, etc. and so on and so forth. Do you follow? Okay. So what are the requirements for retrenchment? Take note, retrenchment is otherwise known as downsizing. It is the reduction of the workforce because the company is losing. Kaya nga, ang separation pay dyan, half-month pay for every year of service. Why? The company is losing. The law is reasonable. Kaya nga, half-month pay for every year of service. So, the usual requirements in authorized causes, 2 separate notice rule. Alam niyo yan, 30-day notice to the DOL, 30-day notice to the employees to be dismissed or discharged. Number 2, reasonable criteria. Under the reasonable criteria, gaya ng seniority rule, pwede rin yung last in, first out. LIFO rule, hindi LIFO. Yung LIFO, liposuction yun. Huwag niyong gagawin yung liposuction. Bakit? Gagawin kayong parang baboy. Titignan niyo. Halukayin yung buong tiyan mo para mawala yung taba. Huwag kayong magpa-liposuction. That is foreign to your body. Gaya ng mga ini-inject sa muka. Kaya yung iba nagiging 2x2 na yung muka. Totoo yan. Tignan niyo si Madam Auring. Si Madam Auring, tignan mo. At saka sila Vicky Bello. Pag nagsasalita, umiiyak ba yun o kumakanta rin? Tumatawa rin ba yun? Oo, tumatawa rin. Gusto niyo ganun? Kaya never engage in this foreign intrusion to your body. Imagine, yung ilong mo, sarat. Gaya ko, ilong ko, medyo sarat. Tapos lalagyan mo ng matangos na ilong. Pag namatay ka, pagdating mo kay sa Supreme Judgment, sabi ng mahal na ama, "Anak, ikaw ba si Maria?" "Hindi, ako po si Maria." "Hindi ikaw si Maria, anak. Ang ginawa kong Maria ay yung sarat ang ilong. Ba't ang tangos ng ilong mo?" "Hindi ikaw si Maria. Punta ka sa impyerno." Imagine, napunta tuloy ng impyerno dahil lang sa ilong. Oh my God. Sige. Masaya kayo rito, no? Labor of love to, ha? Labor of love, no? Okay, let's continue. Again, there must, aside from these reasonable criteria, it must be done in good faith again. Proof of financial losses. How would you prove financial losses? Financial losses shall be what? In the form of an audit finding conducted by an independent, credible external auditor. That is the requirement. Otherwise, if it is conducted by the company auditor, that is self-serving. Another, payment of separation pay, half-month pay for every year of service. So you know now, automation, introduction of labor-saving device, retrenchment. Another is redundancy. You know, in redundancy, according to the Supreme Court, there is no duplication of work functions. According to the Supreme Court, a position is redundant when it is superfluous. And superfluity arises out of some factors, such as what? Overhiring of workers. Overhiring of workers. There are excess services that are not required by the employer. So overhiring of workers. Decrease in the volume of business. Perhaps there was a decrease in the volume of business because of lack of raw materials. Nag-i-import ng mga raw materials into finished products. Hindi dumating. Magkakaroon ng epekto yan. Decrease in the volume of business because of lack of raw materials, as the case may be. Or dropping a particular line of economic activity that has been previously engaged by the employer. In other words, more often than not, in redundancy, there is no duplication of work functions, but there is an overhiring of workers whose services are not economically needed by the employer. So they have to be dismissed. They have to be discharged. Maliwanag. Ganito. Look at me. Dito, the employees of Department A, employees of Department B of the same company. The employees of Department A's functions were transferred and assumed by the employees of Department B. What is the result? The employees of Department A will have no more functions to perform. So their positions become redundant, or the positions have become redundated. Ginamit na rin ng Supreme Court, redundated. No, para hindi kayo magkamali, baka mali spelling nyo si redundated, di redundant na lang. Nakuha nyo. Okay. So that is one instance where redundancy applies. But emphatically, the Supreme Court said that there is no duplication of work functions in a redundancy. Only that the position is superfluous. Hindi superfluous. The correct pronunciation is superfluous. Parang continuous. U-O-U-S yan eh. Alright. Tayo muna. Nakalimutan ko yung kape. Alam niyo, maganda itong kape. Yung nga lang, nakaka-cancer to. Kape pindot. Alright, listen. Another disease. Ito yung sinabi sa Agabon versus NLRC. Dismissal for health reasons. Dismissal for health reasons. So if who has the burden of proof to prove that disease? It is upon the employer. So the employer should prove that the disease cannot be cured within the period of 6 months, and the employer should submit a medical certificate issued by public authority. Yung public authority na yan, baka magkamali kayo, government authority yan. Government hospital, government clinic, government doctor yan. The disease cannot be cured within the period of 6 months. It can be cured within the period of 6 months. Look at me. Then the employee shall be treated as on a leave of absence. And upon restoration of the employee to his normal health, the employee should notify the employer for his reinstatement. For his reinstatement. Not because of illegal dismissal, but because of disease. And despite notice, the employer was obstinate, stubborn in reinstating him back to his former position without loss of seniority rights. The act metamorphoses into a case of constructive dismissal. Tandaan niyo yan. Now again, closure of business. Pagsira ulo ng bar examiner, paghahaluin yung retrenchment at saka closure of business. I gave this in the bar in 2008. But it was not given by Justice Tinga. But this may be given this year. Because what I have submitted is a very good bar question. Pwedeng ganun ang maging ni Manong Doming Tisine. Mabait yun. Huwag kayong maglala. Mabait yun. Like me. Yung mabait, ako super bait. Yun mabait siya, ako super bait. Listen, In closure of business, again, it is a management prerogative to put out of business, to close down the business. Di ba? Okay. But the employer can close down its business for the heck of it, although it's not losing. But generally, when you close down your business, it is because of business losses or economic reverses. Pare-pareho yan. And if the closure of business is grounded on economic losses, serious economic losses, serious business reverses, the employer is not required to pay separation pay. All right, question. Halimbawa, ABS-CBN closed down its radio network. Those who were affected, mga commentators, announcers, the announcers are independent contractors according to the Supreme Court in Jason Saab versus ABS-CBN. Even columnists, writers, columnists of newspapers, they are treated by the Supreme Court as independent contractors because the employer has lesser control. The more control, control. Oh, sigurado, alam niyo yan. More control, employer-employee relationship. There is lesser control, no employer-employee relationship. Simple lang. Sabi nung isa ron, Sir, muscle control. Sabi ganun. All right, listen. So, those who were affected by the closure of the entire radio network filed a case with the Regional Arbitration Branch of the NLRC, having territorial jurisdiction over the workplace of the complainant, National Capital Region. Ano nangyari ngayon? ABS-CBN argued that nag-file sila ng claims including payment of separation pay on the ground of economic losses. Sabi ng ABS-CBN, the ABS-CBN argued, we are not liable for separation pay because the ground for the closure of the entire radio network is economic losses or business reverses. Decide if you were the labor arbiter. Can there be payment of separation pay o hindi na kailangan magbayad pa ng separation pay ang employer? Tignan nyo, economic losses. Take note that in closure of business, you have to consider whether or not the closure is total or partial. If the closure business is total, economic losses ang ground, there can be no payment of separation pay. Pero anong kinilose down ng ABS-CBN? Radio network. Hindi naman nag-close down yung TV network. O may total closure ba? Wala. So ano sabi ng Supreme Court on this matter? Partial closure is treated as retrenchment. Oh. Pwede kayong patayin ng bar examiner dito. Partial closure is treated as retrenchment. Therefore, kahit nag-close down on economic losses, they are entitled to separation pay. Do you follow? Okay. All right. Now, of course, sometimes the employer makes it hard or the employee is compelled to resign or to abandon work or to relinquish his position on account of what? Acts that are what? Disdain, unbearable, which will make an employee file or tender his resignation, which of course you know already, since continued employment has become unbearable under such circumstances, he can file a case of constructive dismissal. So serious insult is an unbearable treatment. The employee, shall I say, can file or tender a voluntary resignation. But when resignation is compelled, that amounts to constructive dismissal because this would become involuntary or forced resignation. By the way, What are the types of dismissal under Agabon versus NLRC? Dismissal for a just cause with due process. Dismissal for an authorized cause with due process. Dismissal without just or authorized cause with due process. Dismissal for health reasons with due process. Dismissal for a just or authorized cause without due process. That is the Agabon doctrine. The dismissal is for a just cause, whether it is just or authorized cause. But for non-compliance of the due process requirement, the employer is liable to pay what? Nominal damages. In the case of just cause, tempered. In the case of authorized cause, fair. And take note, this is a resurrection of the old doctrine of Wenfield versus NLRC. Wenfield, abandoned by Serrano versus NLRC. Serrano versus NLRC was abandoned by Agabon. So Agabon resurrected the old doctrine of Wenfield. And what is this Agabon versus NLRC doctrine? This is known as the belated due process rule. Belated due process rule. Talagang ganyan pag nabibisik ka na dapat kumanta ka. Para ikaw ay humaba ang buhay. Okay. Take note of this belated due process rule. Agabon versus NLRC was already given in the bar in the form of problems. Pero pwedeng ibigay sa bar yan, definition, concept. Explain the concept of the belated due process rule. Anong belated? Wala naman yung belated due process. Violation ng due process. Belated? Patay kang bata ka, hindi mo nabasa yung Agabon versus NLRC. That is simply the belated due process rule. Dismissal for a just or authorized cause without due process. Yan. All right? All right, listen. We will now go to the other gamut of the bar exam. Again, ito binibigay almost every year. These are the usual consequences of illegal dismissal. Ang ginamit ng Supreme Court, consequences, hindi ginamit benefits due an illegally dismissed employee. Anong ginamit? Consequences of illegal dismissal. Kaya pag consequences of illegal dismissal, ito yon. Number 1, reinstatement. 2, full back wages. 3, damages. 4, attorney's fees. 5, other benefits. Do you follow? Maliwanag, ha? Okay, now. So these are the consequences of illegal dismissal according to the Supreme Court. And one of them is reinstatement. You may be asked in the bar on the definition of reinstatement. Oh, it's a simple definition I have crafted. Makinig kayo. Reinstatement is a restoration of the dismissed employee to his former position brought about by illegal dismissal. Di ba simplified? Mamaya sabihin nyo, he's reverted back to his former position. Mahirapan pa kayo. Restoration of the dismissed employee to his former position brought about by illegal dismissal. Simplified. Di ba? All right. There are only two types of reinstatement provided under Book 6 of the Labor Code. And these two types of reinstatement can be applied by the employer at its own option. So there is an option provided by law whether to reinstate an employee actually or to reinstate in the payroll. But before we go into this, let us first have a historical genesis. Genesis. O historical background na lang. Historical background of reinstatement. Under the Labor Code, as to the reinstatement aspect, it is immediately executory, where there is a need for the issuance of a writ of execution. Under the Maranao Hotel case, there must be a writ of execution. But the Maranao doctrine was abandoned by the Pioneer Texturizing Manufacturing Company Incorporated versus NLRC, known as the Pioneer Ruling. Ano ang sabi ng Supreme Court dito? As to the reinstatement aspect, it is immediately self-executory. What do you mean by that? What is the legal implication? As to the reinstatement aspect, said the Supreme Court, the reinstatement is immediately self-executory sans, S-A-N-S, sans, or without writ of execution. Ito, binabanatan ko ito ng, in a sequence, Kaya, sundan nyo lang ako. Alright. So, as to the reinstatement aspect, it is now settled. There's no more need for a writ of execution. Hindi ka na dapat mag-file pa ng motion for the issuance of a writ of execution. If you were an employee where there is an order of reinstatement as per decision of the labor arbiter, what will you do? You can report back for work. Mr. Employer, I have heard the decision. There is an order of reinstatement. I am now reporting for back. I am now reporting back for work, shall I say. Is this allowed under this Pioneer ruling? Yes. Okay, yes. Pwede mong pagawin ng sulat niyang buka. Attorney! Attorney. Bakit? Gusto ko pong gumawa kayo ng sulat for my reinstatement. Can the lawyer prepare a letter for reinstatement? Immediate reinstatement of an employee addressed to the company, especially to the HRD, Human Resources Development Division of the company? Yes. Hindi na kasi kailangan ng writ of execution. Okay. As to the reinstatement aspect, you know this already. There are two types. Optional lang. Under the law on dismissal, there is an option given to the employer whether to reinstate an employee actually or to reinstate an employee in the payroll. However, under Article 263G of the Labor Code, alam nyo, medyo pahirap ng pahirap to. Pero there's no such thing as mahirap. Why? Kung walang kurap, walang mahirap, sabi ni ano. Dito, hindi mahirap ang labor law rito. Dali lang yan. Okay, makinig kayo. Under Article 263G of the Labor Code, the employer is not given the option to reinstate, but the law mandates actual reinstatement. Ano yung Article 263G of the Labor Code? That is a bar area. That is a bar area. Why? That is an exception to Article 217 of the Labor Code of the Philippines. But before we go into this, let's have a short wee-wee. Naiihi na naman. Ito lang, pwede na yan. You just listen. Palagay ko hindi nalulusot dito pag na-discuss natin lahat. Kaya nga, gusto ko i-discuss na lahat, although I was only assigned labor relations. I-discuss ko na lang lahat, no? Yan. Kaya, you attend tomorrow. After this, you attend tomorrow, no? Para you have a backgrounder, full backgrounder on labor law. That I promise you. All right. Ay, umihi yung iba. Makinig kayong mabuti. Under Article 263G of the Labor Code, it only contemplates actual reinstatement. But before, you can have a background of this if you know what is Article 263G. This is actually an exception to Article 217 of the Labor Code. Why? Under Article 217, it says, except as otherwise provided in this code, the labor arbiter exercises exclusive and original jurisdiction over the following cases. Ano nakalagay? Introductory phrase, except as otherwise provided in this code. In other words, under Article 217 of the Labor Code, it enumerates the jurisdiction of the labor arbiter. But it does not mean that although it is exclusive or original, this is limited, conditioned by the introductory phrase, except as otherwise provided in this code. What is the condition? The condition is provided in Article 263G of the Labor Code. Article 263G of the Labor Code is an exercise of the preemptive power. Oh, ano ba kayo? Hindi nyo ba alam yung preemptive power na yan? Article 263G is an exercise of the assumption or preemptive power of the President or the Secretary of Labor over a labor dispute in an industry indispensable to national interest. Under the old labor code, vital industries ang tawag. Under Republic Act 6715, industries indispensable to national interest. Ganito yon. Hindi nyo makakalimutan to because this is applicable to an actual case of PAL where the government, the President's office, intervened into the resolution of the labor dispute at PAL because that is a transportation business. Is it an industry indispensable to national interest? Yes. Can the President motu proprio intervene? Yes. Yes. Now, question. May the union file a petition for intervention? Yes. File a petition for assumption? Yes. May the employer file a petition for assumption with the Office of the Secretary of Labor? Yes. Or it can be done motu proprio. Mamaya sabihin nyo, ang magpapel na ng motu proprio or ang employer. Hindi pwede. Either motu proprio, petition, or motion by the employer, a petition or motion by the union for assumption of jurisdiction. Okay. Because I cannot discuss this actual reinstatement without discussing the entire subject matter. And take note, the legal effects of an assumption order, each and every legal effect is a potential bar question. Kaya makinig kayo. All right. In the event the President issues an assumption order, what are the legal effects? Or when the Secretary of Labor issues an assumption order or the preemptive order, what are the legal effects? Number one, upon the issuance of an assumption order, the striking workers should now report back for work. So with the assumption order, the striking workers should stop striking and report back for work. Number two, if they do not report back for work, anong sabi ng Supreme Court? If they do not report back for work and continue with their strike activity, they are now engaged in a prohibited activity. Therefore, the strike is illegal. The assumption order has an effect of a writ of injunction without compliance for the requirements of a writ of injunction. So take note, yung assumption order has the effect of a writ of injunction issued either by the President or by the Secretary of Labor. Now, a return to work order is deemed written into the assumption order. Look at me first. Ganito yun. Pag meron bang assumption order, is there a need for the issuance of a separate return to work order? Sabi ng Supreme Court, hindi na. That is deemed written into the assumption order. Kaya kung halimbawa, the union receive an assumption order, tinawagan ng union president yung abogado nila, Attorney, o bakit? Naka-receive kami ng assumption order ng Secretary of Labor. Meron bang return to work order? Wala po. Ay, pabayaan nyo yan. Bobo. Bobo yung abogado. Imagine, isinadlak niya sa dusa yung union. Bakit? If they do not report back for work, they can be dismissed. Sasabihin niya, ay, hintayin niyo yung return to work order. Pag walang return to work order, huwag kayong bumalik. Ano ba sila? Naku, ang yabang pa. Yung pala, ob-ob na, ogag pa. Alam niyo yung ob-ob? Bobo na, gago pa. Ogag pa. Oh, tignan niyo. Kaya alam niyo, kung minsan, ang kliyente nasisira dahil hindi sa abogado eh. Dahil sa hindi nag-aaral. Imagine, sasabihin niya, huwag kayong pumunta, huwag kayong bumalik. Walang return to work order. Dapat may return to work order yan. Patay kang bata ka. Dismiss lahat ang kliyente niya. Take note, a return to work order is deemed written into the assumption order. Naliwanag? Another! All cases cognizable by the labor arbiter that are presented as issues under his assumption are cognizable by the Secretary of Labor and Employment. Kaya yung legality of dismissal, legality of strike, picketing, etc. If these are issues under assumption, the Secretary of Labor has concurrent jurisdiction. Why concurrent? Because it is cognizable also by the labor arbiter. But extraordinarily, under Article 263G of the Labor Code, they are given the power to resolve it, provided they are under assumption. Why? Because they are issues presented under the assumption of jurisdiction or preemptive jurisdiction of the Secretary of Labor and Employment. Naliwanag? Another. Listen. Assumption of jurisdiction contemplates only actual reinstatement. Yan yung sinasabi ko. Kaya ako diniscuss na ito kagad. Hindi nyo maiintindihan yung actual reinstatement under Article 263G kung hindi ko i-discuss yung preemptive power ng President or Secretary of Labor. Now, so, if there is an assumption order issued, it is now incumbent upon the striking workers to report back for work. Ano ang dapat gawin ng employer? The employer should admit them back, accept them back, or reinstate them actually. Hindi sa payroll. General rule lang, actual reinstatement. Now, if actual reinstatement is not possible or legally impossible, physically impossible, physically impossible, ano sabi ng Supreme Court? Under special circumstances, they shall be reinstated in the payroll. That's the case of UST Faculty Union versus UST. Ganito yan. Di nag-strike yung mga faculty. Faculty. Ano nangyari ngayon sa mga faculty? Nag-strike, nag-assume ang jurisdiction ng Secretary of Labor. But when the Secretary of Labor assumed jurisdiction over a labor dispute at UST, it was already mid-semester of the school year. In the meantime, they were replaced by replacement teachers already hired by UST. Siyempre, hindi po pwede yung walang magtuturo. Magtuturo. Oh. Kasi yung nagtuturo ko minsan, nagtuturo rin eh. Oh. Magtuturo. Now, merong assumption order. May nagtuturo na, replacement teachers. Oh, it's incongruous. It is awkward to see two teachers in the same room. Oh, biology. Nandun yung biology teacher na isa. Yung isa nandun. Sabi ng isa, mali yung signal. Siyempre, mag-aano yung mga estudyante. Ano ito na to? Pangit tignan. It is physically impossible. Bakit? Because of Imagine a situation where you allow two teachers teaching the same subject during the period. That is a special circumstance which will not allow actual reinstatement, but payroll reinstatement. Do you follow? Sa loan dismissal, may option. Kung hindi pwede actual, payroll. Sa loan assumption of jurisdiction, actual reinstatement, general rule. Exception, payroll reinstatement. Maliwanag. Pag hindi niya nakuha niyan, sasabunutan ko kayo. Pag binigay sa bariyan. Alright, let's continue. Alright. As to the actual reinstatement and payroll reinstatement under the loan dismissal, under the Hinu case, the Supreme Court said that if an employee was reinstated in the payroll pending appeal, he is entitled to his salaries. Even if it reaches the Supreme Court. Pending appeal, he is entitled to his salaries unless through the final verdict of the Supreme Court, there was finding of legal dismissal. From the finality of the decision, there can be no payment of salaries anymore. Now, question. If there is finding of legal dismissal, should the employee refund whatever salaries he previously received? Sabi ng Supreme Court in Hinu, yes. But in the case of Torres versus NLRC 2008 case, sabi niya, hindi na pwede. This was resounded in Garcia et al. Versus PAL, January 2009 case, cut-off date June. Pwedeng ibigay ito. Now, if you want to be, of course, the decision of the Supreme Court shall prevail. Because here, the Supreme Court applied the principle of social justice as superior over a civil law doctrine on unjust enrichment. Pwedeng ibigay ito. Itong area na ito. Oh, I can feel it. Oh, umiinit ang ano ko eh. Umiinit ang pet ko. Sabi ng isang estudyante ko, Sir, ang galing ni Justice Isagani Cruz. Bakit? Puitik. Puitik daw. Ano yung puitik? Yung pala poetic. Sabi niya, puitik. Diyos ko hindi ko naintindihan nung una. Sir, puitik. Anong puitik? Yung pala poetic ang approach niya sa pagde-decide. Sa bagay, maganda si Justice Poetic. Hindi puitik. Kaya tandaan nyo, pag naging abogado kayo, baka magkamali ko sa pronunciation nyo. Sa bagay, yung mga kapampangan, talaga hindi mo maaalis yan, no? Walang H. Buhay. Buay. Buhay. Talagang walang H, Sino kapampangan dito? Wala? Misis ko kasi kapampangan eh. Kaya nung tinanong ko misis ko, bakit kayo walang H? Sabi niya, hindi naman lahat. Hindi naman lahat. Wala ring H pala. Hindi naman lahat. Sabi niya, taga San Fernando, Pampanga. Hindi naman lahat. Sabi niya, di wala ring H pala. Nasira utak ko ron. Sabi, hindi naman lahat. Alright, let's continue. We are still on reinstatement. So if this is given on the bar, you can cite the Hinu, but this was already abandoned in a later case. Do you follow? Yung Torres versus NLRC at saka Garcia et al. Versus PAL, 2009 case. Ha? Maliwanag? Yes. Hindi ba na-discuss ng kumpare ko, si Oswald yan? Yung 2009 na yan, yung Inuino, abandoned, hindi na-discuss. O, tignan nyo, buti nandito kayo. Kaya, alam nyo, napipil ko, pati bilbil ko, umiinit, kaya dapat, lalabas yan. Lalabasan na talaga yan, lalabasan na. Okay, let's continue. Ito, binigay sa Barto last year, but we have to reiterate this in this review. What are the instances under the law where reinstatement is not feasible? Or in my book, I provided there instances where reinstatement is barred. Barred, B-A-R-R-E-D. All right, number 1, where reinstatement is barred, dismissal for cause. If you were dismissed for cause, reinstatement is not proper. Number 2, under the principle of waiver or laches, the Supreme Court said that your right is protected if you assert it within the prescriptive period. If you do not assert it, it becomes a stale claim under the principle of waiver or laches. Okay. Sa illegal dismissal, what is the prescriptive period for reinstatement? Calianta versus Carnation, in the case of illegal dismissal, what is followed is the civil law doctrine on prescription, which is 4 years, not 3 years under the labor code. Now, pwedeng ibigay sa Barto. Why is it that in a case of illegal dismissal, the prescriptive followed is not the labor code provision but the civil code provision on prescription of claims under Article 1146, which is 4 years. Pag binigay sa baryan, you look at me. This is the answer. Ano? You say, you avert that in a case of illegal dismissal, there is injury to the constitutional right of workers. Ano yung injured? What constitutional right of a worker that is injured? That's why you apply the Article 1146 of the Civil Code on prescription of claims. Ano? Injury. There is injury to the right of the workers. Due process. Nandyan, due process under the Article 3, di ba? Equal protection. Ano pa? The right to property. Di ba sabi ng Supreme Court, the right to labor is treated as property within the mantle of constitutional protection. Article 13, ano? The right to security of tenure clause of the Constitution. That is impaired with what? Illegal dismissal. That's why if the case of in the case of illegal dismissal, if the dismissal is done in bad faith or in a wanton, oppressive, malevolent, disdain, cruel manner, the employee dismissed is entitled to damages, but this should be proved by way of substantial evidence. So take note of that. All right. Another, where there can be no reinstatement, if the position is filled up, if the position is abolished. If the position is filled up already, or if the position is abolished already, there is still a requirement of the law. And that requirement refers to reinstatement of the dismissed employee to a substantially equivalent position. To a substantially equivalent position. Take note of that. Now, if there is no more position that is equivalent, a substantially equivalent position, then what is the proper disquisition under the circumstances? What is the proper disquisition? Proper remedy? What is the proper proposition? Preho lahat yan. Ano? Payment of separation pay plus back wages. So in lieu of reinstatement, ano? Separation pay plus back wages. In lieu. Sige, yun ang alam nyo, in lieu. Another, under the principle of strained relationship, pag nagbigay sa bar tungkol sa strained relationship, ito ang tandaan yung terms. More often than not, if there is a strained relationship as between the two parties, the employer and the employee, there is already what we call severe antagonism. Tandaan niyo yun. Yan ang ilalagay niyo. Hindi ako may sabi niyan. Sabi ng Supreme Court. Considering that there are charges and counter-charges between the employer and the employee and the employee cannot see eye to eye with each other. So, reinstatement is nil. Why? Because of severe antagonism. Repeat that. Yung entire. Hindi nyo na alam. Severe antagonism. Okay? Maliwanag ba? Para bang nakikita ko sa inyo parang sini, no? Na, maliwanag ba? Sabihin nyo, kung hindi maliwanag, sasalsalin ko pa ng husto. Walang problema. Babatihin ko ng husto yan. Mami, baka nagagalit na yung mga pari. Sabi, sasalsalin, babatihin. Sorry, Lord. Another. In the case of physical disability, if in the meantime the employee is disabled, the proper remedy under the circumstances is to what? It's not reinstatement, but payment of separation pay plus back wages. If the employee has become overage na, i-reinstate mo pa? May lupa na yun. Ano sabi ng Supreme Court? Reinstatement is not proper. What is the proper remedy under these circumstances? Payment of separation pay, back wages. Ganun lang. Ganun lang palagi. Ano pa? Well, in the case of prescription, what is the prescriptive period for reinstatement? 4 years also. 4 years. Ano ba kayo mamaya magbigay sa prescription? Hindi nyo alam. Idikta ko lahat ng prescription. Gusto niya? Sige. Illegal dismissal, 4 years. Reinstatement, 4 years. Purely money claims, 3 years. Incremental proceeds out of tuition fee hikes, 3 years. Unfair labor practice, ULP, 1 year. Union funds claims, cases on union funds, 3 years. Employees' compensation claims, 3 years. Criminal cases under the Labor Code. Criminal cases under the Labor Code. As a general rule, 3 years. Except, may exception yan. Number 1, simple illegal recruitment, 5 years. Large-scale and syndicated, 20 years. In the case of sexual harassment under sexual harassment law, 3 years. Exception. Ano sabi ng Supreme Court in one case? Nasal batas, 3 years. Sabi ng Supreme Court, no prescription. It can be filed even after 4 years. Digital case yan, digital case. Digital communication case. GSIS claims, 4 years. SSS claims, 10 years. But as to the assessment of premium by the government from the time of assessment of for the payment of premium, the prescriptive period is 20 years. Oh, alam niyo na. Bakit importante ito? Dahil doon sa illegal dismissals, nagbigay na ng bar exam sa 4-year prescriptive period. Ano malay nyo? Magbigay ng prescriptive period sa reinstatement. Okay? O another, where reinstatement is not proper. Closure of business. It is impossible to reinstate an employee where in the meantime, the employer has already closed down. That is the case of Chronicle. Yung Manila Chronicle, Manila Chronicle case yan. Another, reinstatement is not proper as mandated by law. Umalis na yung sweetheart ko. Nawala tuloy ako. Saan ba? Mandated by law. What is this law? Which provides that there is no reinstatement. This is the case. This is a law on migrant workers and Overseas Filipino Act. Section 10 of Republic Act 8042. Republic Act of 8042 as amended by Republic Act 10,022. There is a new law amending Republic Act 8042, 10,022. Bakit? Walang reinstatement dito. The overseas Filipino workers is only entitled to reimbursement of the placement fee in the case of land-based workers, plus the unexpired portion of the employment contract. So the 3 months per year basis in determining back wages under Section 10 has already been declared unconstitutional by the Supreme Court in the case of Gallant Maritime. Ano sabi ng Supreme Court dito? It is violation. It is a violation of the Equal Protection Clause of the Constitution because the law provides for full back wages, not 3 months per year basis, but it is full back wages. So violation of the Equal Protection Clause of the Constitution. Therefore, anong basis ngayon ng award of back wages? The unexpired portion of the employment contract. Kaya kung 12 months, dinismiss there was an illegal repatriation. Take note of this. This is being used, applied in overseas employment. Yung involuntary repatriation, illegal repatriation, that is constructive dismissal. That is illegal dismissal. Pero yung voluntary repatriation, that is resignation. O baka ibigay sa baryan, ha? Alright. So alam nyo na to. By mandate of law, there can be no reinstatement. Ano pa? Under the principle of fiduciary relationship. Itong fiduciary relationship, take note of the fact that an example of this is a house helper. You know, the house helper enjoys trust and confidence. So, if the house helper is illegally dismissed, there can be no reinstatement. Why? Ang gagawin ng house helper dito, lalasunin ka. Lalasunin ka, o kaya susunugin ang bahay mo. Ano pa? Gagawin mo tilang bahay mo. Sabi niya sa boyfriend niya, 1:00 ng gabi, ha? Bukas na yung pinto, pasok ka. Ano, gusto niya yun? Gagawin mo yung bahay mo? Worst, pag pinagprito mo ng hamburger, lalagyan niya ng kulangot. Kaya ang tawag ko dyan, kulangot doctrine, Yung fiduciary relationship na yan, kulangot. Bakit? Sabi nung house helper, makakabawi na ako kay ma'am. Sabi ganun. Habang nagpapa-init, sunbathing yung ang laki ng tiyan along the pool, no? Sa side ng pool. Ang laki ng tiyan nung yung lady employer. Sabi niya, Inday, upo ma'am. Pakiprito nga ng hamburger. Upo ma'am. Sabi niya, kakabawi na ako. Suminga ng suminga. Nilagyan na. Tapos nangulangot, nilagyan niya. Binuksan niya yung burner. Pinainit niya, nilagyan mantika. Psss! Inalis niya. Nag-cut siya ng freshly cut tomatoes. Nilagyan pa ng mustard sauce, no? Sarap nun. Tapos, ma'am, nandito na po yung hamburger. Hindi na hamburger. Hamburger. Bakit? Kulangot ni. Ano, gusto niya yan? Tandaan niya yan. Kaya pag binigay sa bar yan, huwag niya ilalagay yung kulangot doctrine. on the ground of fiduciary relationship. Okay? You know, as you increase your stamina, sometimes use up na yan later on. Kaya, importante ito Ganon din kayo. You take lipobitan sa early morning, tapos another lipobitan sa tanghali bago kayo para Kasi talagang mababawasan yung energy nyo. Kung gusto nyo, Yakult. Mag-Yakult ka! All right, let's continue further. So we have this reinstatement people, no? Another, we have full back wages. In full back wages, you have to consider the cut-off date. I gave this in 2008, but the bar problem I have submitted was not given by Justice Tinga. I had submitted a bar question where I applied the cut-off date on the application of the full back wages doctrine vis-a-vis or versus the 3-year back wages, otherwise known as the Mercury Drug Doctrine, 3-year back wages doctrine, or otherwise known as the T-Hanky formula. All right, what is the cutoff date of the full back wages doctrine? March 21, 1989. So, if the case were filed prior March 21, 1989, then the prevailing doctrine would be the case decided by the Supreme Court in 1974, Mercury Drug Company Incorporated versus CIR, otherwise known as the 3-year back wages doctrine or the Mercury Doctrine. But if it was filed on March 21, 1989, and thereafter, the prevailing doctrine would be full back wages. What do you mean by full back wages? It simply means back wages, not subject to qualification or deduction. Where income from other sources cannot be deducted from back wages. Yun ang ibig sabihin ng full back wages. Maliwanag? Okay. Another, we have damages. In the case of damages, people, take note that the Supreme Court said that if the dismissal was done in bad faith, in an oppressive, malevolent, whimsical, cruel, or in a disdain manner, the employee dismissed is entitled to damages. Question: what are the types of damages that can be awarded by the labor arbiter? Sabi ng Supreme Court, all types of damages. Not only damages under the Labor Code, but also damages under the Civil Code. Ano ba kayo? So, if the dismissal was done in bad faith, or in an oppressive, malevolent, whimsical, cruel manner, the employee is entitled to damages. But the damages shall be proven by substantial evidence. So, how would you prove substantial evidence? Sabi ng Supreme Court, it is not sufficient to state the grounds for the award of damages such as sleepless nights, wounded feeling, besmirched reputation, mental shock, moral suffering, etc. Ang nilagay mo ron, ganun lang. Pero you did not submit evidence to prove this award of damages. Sabi niya Supreme Court, it's not a mere recital of the grounds, but these grounds must be supported by substantial evidence. So, ano yung substantial evidence? Ganito yon. Halimbawa, employee na dismissed. He filed the case of illegal dismissal. Pero nung nag-file siya ng illegal dismissal dahil sa kanyang emosyon, inatake siya sa puso, dinala sa ospital. Yung doctor's bill, hospital bill, receipts for medicine, all of this shall be submitted. Kung hindi mo sinabmit yan, ano sabi ng Supreme Court? If this substantial evidence were not submitted, there is no ground for the award of moral damages. If there is no ground for the award of moral damages, it follows there is no ground for the award of exemplary damages, which is corrective in nature. And if there is no ground for the award of moral and exemplary damages, there is no ground for the award of attorney's fees. That is the case of Ojon Electric Company. Hindi pa binigay sa bariyan. Hindi pa. Hello? All right. Another. We have now these attorney's fees. Attorney's fees. Under Article 111 or Article 222? 111, 222. 222, yung ano yung sa globe yun, 222. Yung ano, 1515. Sa 111, what kind of attorney's fees awarded under Article 111? Alam niyo hanggang ngayon yung ibang mga bar candidates, hindi pa alam kung ano yung attorney's fees under Article 111. Take note that these attorney's fees awarded by the labor arbiter under Article 111 are in the form of damages. Kaya nga sabi ng mga bar candidates na iba, that the client, employee, and his lawyer cannot, that the labor arbiter cannot award attorney's fees beyond 10%. That is correct under Article 111. Because the law fixes damages under Article 111, not to exceed 10%. But it does not disable the complainant employee and his lawyer to agree on other forms of contract. Hindi as to attorney's fees. Halimbawa, walang acceptance fee. Walang appearance fee. Walang pleading writing fee. Walang merienda fee. Walang success fee. Ano pa man dyan? Is it only proper that the employee, the lawyer should be given a higher amount of attorney's fees? Yes. Perhaps on a contingency basis of how much? 20%, 30%, 40%. Do you follow? Pwede ba yun? Yes. Now, kung walang kontrata, then the principle of quantum meruit shall apply. Alam niyo na yan. So take note of these people. Itong attorney's fees. Now, according to the Supreme Court, as to the award of damages and attorney's fees, the factual and legal basis for the award must be discussed by the labor arbiter in the text of the decision itself. Tandaan nyo, hindi lang basta-basta na i-award yung damages at saka yung attorney's fees sa dispositive portion. Ano sabi ng Supreme Court? This should be discussed as to the basis, should be discussed in the text of the decision, not only awarded in the dispositive portion. If there is no basis, if it were not discussed in the text of the decision of the labor arbiter, there is no basis for the award of moral, exemplary damages and attorney's fees. Maliwanag? Okay. So let's have a short break of 1/2 minute. Hindi. Ihi muna tayo. Pagod na. Saka mainit yung pit ko.
Meron din. Sino nandyan sa iyo? Si Halina? Katrina?
Area. I'll go to another area. So let's say we have these types of employment every year nagbibigay dito. So what are the types of employment under Book 6? We have regular, casual, probationary, fixed term, seasonal, project, non-project. I also gave one bar question here in determine whether it is regular or not, no? So you should know the indicia or the indications or the principles underlying regular employment. In other words, people, the law, another existing jurisprudence, provide for certain criteria in determining whether or not an employment is regular. So under regular employment, the following are certain principles or criteria or indications or indicia of determination. We have number 1. The employee performs job that is usually necessary and desirable to the usual business of the employer. It is double ang usual doon. Usually necessary and desirable to the usual. Dalawang basis ginamit yung usual. Usually necessary and desirable to the usual business of the employer. Like in the case of a teacher or a professor. In the case of a teacher performing job, what? Teaching. Is teaching usually necessary and desirable to the usual business of Recoletos? Yes. That is one principle or indication of regular employment. I'll give you a concrete example na hindi nyo makakalimutan. Gaya ng auto repair shop. This is my usual example. Since 1986 pa ito nung nag-review ko sa bar. 1986, ano ngayon? 2010 na. Oh. Ano? Auto repair shop. Is the service of a mechanic or the position of a mechanic usually necessary and desirable to the usual business of the employer? Auto repair shop? Yes. What about yung pintor? Yung pintor, kukuha ng brutsa, tapos meron diyang pintura, isasawsan niya yung brutsa, tapos bubrutsahin niya ngayon yung sasakyan. Yung brutsador. Alam niyo yung brutsador? Brutsador, pintor, pareho riyan. Brutador. Yung iba nandito. Yung iba naman dito. Alam ko lahat yan. Pinagdaanan ko yan lahat eh. Kaya hindi nyo maluloko. Yung iba naman dito. Paano yun? Hindi nyo makakalimutan, Brutador, ha? He performs job that is usually necessary and usually in the usual business of the employer. Tandaan niyo yan. Another principle, criterion, indication, indicia. In the case of, halimbawa, auto repair shop, nasira yung bubong because of typhoon, ano ba yung latest? Basyang. Nabutas yung bubong. The auto repair shop owner hired the services of a carpenter to repair the roof of the auto repair shop. Does he perform job which is usually necessary and desirable to the usual business of the employer? Ano ba kayo? No. Sabihin nyo, no. The carpenter performs job. No, the carpenter is not a regular employee because he performs job that is not usually necessary and desirable to the usual business. Ganon ang pag-answer sa bar. So you should know these principles. Hindi yun, well, sabihin nyo, well, meron pang well. The carpenter is not a regular employee because he's only assigned to repair the roof of the auto repair shop. Therefore, he is not, therefore na naman, therefore he is not a regular employee but a casual employee. Wala, patay na. Anong answer doon? Is he a regular employee? No, period. The carpenter is not a regular employee because he performs job that is not usually necessary and desirable to the usual business of the employer. That of what? Repairing only a dismantled roof of the auto repair shop. Pero dapat alam mo yung principle. He performs job which is usually necessary or he performs job that is not usually necessary. Therefore, period, therefore, the carpenter is a mere casual employee. Ganon ang pag-answer sa bar. Perhaps this is your first time to answer bar questions like that in a manner which is suitable to the likes of the bar examiner. Ganon ang pag-answer sa bar. Do you follow? So you are very lucky. Very rocky. Sabi nung Mr. Biacero. All right, another indication or principle. He renders services for at least 1 year, whether such service is continuous or broken or intermittent or off and on. Pare-pareho yan. Is there such thing as permanent casual? Of course, when you talk about permanent casual, he is a regular employee because of what? Anong indication dito? Principle. He performs job, he renders services for at least 1 year, whether such service is continuous or broken. Kaya yung 555 policy ng SM, yes, there is such thing as 555 policy, but that amounts to regular employment because the law says he renders services for at least 1 year, whether such service is continuous, tuloy-tuloy, o kaya putol. Anong gusto niyo? Pareho rin. Regular pa rin yan. Kaya yung iba, nag-ano ng contractualization, aalisin yung contractualization. Well, actually, the labor code is emphatic. Sabi ng labor code, if he render services for at least 1 year, he is a regular employee. Di ba? Okay, now, another indication, constant renewal of contract. Constant renewal of contract, constant rehiring amounts to regular employment. But you have to consider that he has already rendered at least 1 year service. But what is the exception to this principle? That despite constant rehiring, constant renewal of contract, the employee is still not a regular employee. That is in the case of Miliares versus NLRC. The case of an overseas Filipino worker including seamen. Why? Because seamen or overseas Filipino workers are employed for a fixed period, of employment or basis. What do you mean by fixed term employment? Hanggang ngayon, di nyo alam? Fixed term employment is contractual employment. So take note, seamen, despite constant rehiring of these people, can never, sabi nga ng Supreme Court, can never attain regular employment because they are employed for a fixed term basis. But as a general rule, constant rehiring, constant renewal of contract indicates regular employment. Another, in the case of expiration of the training period, upon expiration of the training period, the law says so, that a trainee may become a regular employee. You know, when you talk of training period, this is the period when the worker has to learn the skills of the job. The training period is otherwise known as the trial period. And the training period is also treated by the Supreme Court as a probationary period. So the apprenticeship period, learnership period, the training for a handicapped worker is a probationary period already. So, if this is given in the bar, let's say, halimbawa, tinanong sa bar, pagkatapos ng apprenticeship training period, tinawag siya ng employer, Mr. Apprentice, alam mo, bata, ang galing mo. One day na lang, matatapos ka na sa apprenticeship mo. Ang galing mo. I gave you 100% in your rating. Kaya gusto kong maging regular ka. Opo, sir. Maraming salamat po, sir. Okay. Gusto ko maging regular ka. Maraming salamat po, sir. Maiyak-iyak pa. Okay. Now, bibigyan kita ng isang buwan na maging probation ka, maging probationary employee ka. Pagkatapos ng 1 month, ikaw ay regular na. Maraming salamat po, sir. Is the agreement valid? Of course, the agreement is not valid. Why? Because that would amount to Ano tawag doon? Double probation or successive probation. Kala ko ba alam nyo na yan? Maswerte kayo, nandito kayo. Maswerte kayo. Yung nga lang, wala na ako ng pre-week dito, okay lang. Pero this is your pre-week already. You just listen. This is your pre-week. You just listen. So according to the Supreme Court, the training period is itself a probationary period. So if you require again an apprentice, a learner, or handicapped worker to go on probation, that is a prohibition. That is proscribed, prohibited under the law. It's against public policy because it amounts to double probation or successive probation. What is allowed under the law is what? Giving a trainee a certain period of time to what? To acquire perfect rating during the training period. Halimbawa, 75% ang ranking niya, yung grade niya, yung rating niya, sabi ng employer. Alam mo, bata, sa training mo, medyo 75% ka eh. Gusto ko maging 100% ka, bata. Pwede bang extend natin ng konti yung training period mo? Opo, sir. Maraming salamat po, sir. Malaking utang na loob ko po, sir. Okay. Is this allowed under the law? Yes. This is probation by extension, by agreement of the parties, which is allowed under the law. Naliwanag? Okay. So upon expiration of the training period, and take note, people, that the labor arbiter has no jurisdiction over violation of training agreements. Although training agreements are employment contracts, it is beyond the jurisdiction of the labor arbiter, as already declared by the Supreme Court in Singapore Airlines versus Panyo. All right, another indication of regular employment upon expiration of the probationary period. In one case, the Supreme Court said that the employer can require the employee or the probationary employee to comply with certain prescribed standards, but this should be made known personally to the employee. But if there are no prescribed standards, take note, if there are no prescribed standards by the employer and he was employed by the employee, then the Supreme Court said he is not on probation, but automatically he becomes a regular employee. Any one of these can be given in the verb. Basta importante yung principle alam ninyo. So if there are prescribed standards and there was a period provided by law upon the expiration of the probationary period, he becomes a regular employee. Now question. Is there a fixed term on probationary employment? How many months? Ano ba kayo? That is the general probationary period. Tignan nyo. Sabi nyo 6 months. Pwedeng 2 months yan, pwedeng 1 month yan, pwedeng 6 months, pwedeng 10 months, pwedeng 18 months, pwedeng 12 months. 6-month period provided under the Labor Code is a general probationary period. Now, pag halimbawa, sabi ng employer, 2 months probation, allowed by law? Yes. Sabi ng employer, 18 months. May magagawa ka ba pag sinabi ng employer, 18 months? Why? Because of the nature of the job requires extensive training. Halimbawa, the employer is engaged in the manufacture of atomic bomb. Under probation ka. Kahit na 2 years na, 3 years pa, alam mo bang gumawa ng atomic bomb? You know, I'm fan of extreme examples because you need extreme examples to pass the bar para hindi nyo makalimutan. Why? The nature of the job requires extensive training. This is the case of PLDT. 18-month probationary period, sabi ng Supreme Court, allowed. Nakuha niya? 2 months for the benefit of the employee. Allowed. 12 months, 18 months. Allowed? Yes, because the nature of the job requires extensive training. Oh, ano ngayon? Nasaan na kayo? Ay, probationary period, 6 months. May nagtanong sa inyo, ikaw graduate ka na ng law. Oo nga, kumuha na ako ng bar eh. Ano bang probationary period? Oo, 6 months yan. Patay kang bata ka. Sabihin mo, that is the general probationary period. Tingnan niya. Kaya 2 months, 3 months, 5 months, 6 months, pwede yan. 12 months, pwede yan. 18 months, PLDT versus NLRC case. Tingnan niya. All right, Another principle of regular employment. In the case of project employment, a project employee is one who is hired to perform a specific undertaking or project. Upon the expiration of the project, or if the project is terminated, automatically there is rupture of employer-employee relationship without notice of termination. Kasi for specific undertaking. Kaya nga project eh. Now, when may project employees become regular employees? Oh, look at me. Baka magkamali kayo. Ano sabi ng Supreme Court? The law requires in project employment that upon termination of each project or undertaking, a report shall be made to the nearest DOL office on the project terminated and the employees terminated. May report system yan. As there are several projects terminated, there are as many reports to be made. No reports made by the employer. Sabi ng Supreme Court, since there were no reports made by the employer, despite several projects terminated, the employees are not project employees, rather, they are regular employees. All right, another. Hindi natin pwedeng palusutin ang bar-examiner dito sa employment na to. Another. Non-project employment without regard to specific project or undertaking. No? But take note, in non-project employment, please take note that they are also required to go on a probation. So, if you were a non-project employee with a probationary period, upon expiration of the probationary period, you are or you become a regular employee. Why? In non-project employment, the workers are actually workers belonging to the work pool. May work pool yan. Halimbawa, work pool tayo dito. Nakuha niya? Nandiyan ang pintor, brochador, merong architect, engineer, doctor, Lahat. Yung construction workers, nandyan na lahat. And the employer has several projects. A, B, C, D, E. Doon sa project na ron, there are several phases. Okay. Can the employer take out and assign an employee from the work pool and be assigned to one project A? Yes. Kinuha niya sa project A, itinransfer niya sa project C. Pwede? Yes. Why? Because the workers belong to the work pool. Yan ang non-project employment. Maliwanag? Okay. Ano pa ang indication ng regular employment? Lalong-lalo na sa seasonal employment. Sabi ng Supreme Court ganito, look at me with your big eyes. Sabi ng Supreme Court ganito, if a worker or employee is employed from season to season, hindi SIO, SISON. Mamaya, season to season. Ano mo sino yung estudyante ko sa PCC noon? Si Marco Season. Nag-estudyante ko yun eh. Kami nila Villardiano, nag-estudyante namin sa PCC yun. Season to season. Naalala niya, hindi SEA, SON. Naalala niya si Marco Season dahil sa mahilig siyang kumanta ng My Love Will See You Through. Kaya naalala season. Okay. If an employee is employed from season to season, ano pa requirement? Performing the same task. Take note. Performing the same task. He is treated as a regular seasonal employee. Now, in the case of project employment, are project employees entitled to reinstatement and full back wages? Yes. If prior the expiration of the project, he was illegally terminated or illegally dismissed, he's entitled to reinstatement plus back wages accruing to the certain period of time, yung unexpired portion. Do you follow? So, applicable din yung reinstatement and full back wages as far as project employees are concerned. Do you follow? Maliwanag ba? Hindi? Okay, maliwanag ha? Okay. So, regular, casual, seasonal, project, non-project, employees or employment. May nakalimutan ako. Substantive, tapos na tayo yung procedural. The procedural aspect of due process refers to what? It refers to the two-notice rule and hearing. What are the steps here? Yung two-notice rule, number 1, first notice. Ano yung first notice? The purpose of the first notice is to inform the employees of the charges against him. Kaya nga, yung first notice refers to the formal charges. Kung abandonment yan, serious misconduct yan, act of dishonesty yan, insubordination yan, o willful disobedience yan. Okay? Number 2, answer. That is the next step. Answer. Anong sabi ng Supreme Court? Upon receipt of the formal charges, the employee shall be given to provide or to give out an intelligible answer. That is a requirement of the precept of due process. Number 3, hearing. The Supreme Court says that there must be a hearing. A hearing cannot be substituted by mere audit finding, question and answer, etc. But in another case lately, ano sabi ng Supreme Court? Even a hearing is not conducted provided that the employee is given the opportunity to be heard, such as what? Requiring him to give an answer, and he provided or submitted an answer that is sufficient compliance according to the Supreme Court with the due process requirement. Take note that technical rules are not binding but resort to amicable settlement provided under Article 221. Technical rules are relaxed in labor proceedings pursuant to what doctrine? The doctrine of speedy labor justice. The doctrine of speedy labor justice. That is the legal anchor of Article 22. That's the legal anchor, yung Article 221 of the Labor Code. After, while the hearing is conducted, assuming there is a hearing being conducted, can there be a preventive suspension? Yes. If his presence in the company premises will pose threat or danger to the company and his co-employees. But you have to consider the nature of the job. Halimbawa, clerk lang. Can she pose danger to the company and to the co-employees? Can she pose threat and danger to the company and his co-employees or her co-employees? Of course not. What if the one suspended is a security guard, a black belter, a former Marine sergeant, former Marine, an expert in making bombs, a bomb expert, bomb expert? Oh, is there basis for preventive suspension? Yes. Preventive suspension applies only for a period of how many days? 30 days. If it is extended, the employee is entitled to his full month pay. Pag hindi siya binigyan ng full month pay, that metamorphoses into a case of constructive dismissal. Also, demotion in rank, reduction in pay. If an employee, such as a security guard, on a floating status, what is floating status? Off detail status. Ano pang tawag doon? Off detail. Wait, ano yung floating status? Waiting to be posted. Yan ang ibig sabihin niyan. Waiting to be posted. If after 6 months, wala pa, he is not yet assigned by the security company or agency, because the real employer here is the security agency. Take note of that. It's not the employer where he is assigned by the security agency. The real employer is the security agency. Baka magkamali kayo. So, if he is not assigned by the security agency, again, ano sabi ng Supreme Court? That metamorphoses into a case of constructive dismissal. You were relegated to the background. Before, you were a chief engineer. Later on, you were assigned as a chief bodeguero. Oh, there is a reduction in your rank. So that amounts to constructive dismissal. Reduction in pay amounts to constructive dismissal. Demotion in rank amounts to the constructive dismissal or constructive discharge. Pare-pareho yan. Or technical dismissal. Pare-pareho yan. So if you are assigned in a place where you are not competent, capable, qualified, you can file or tender your resignation. That amounts to constructive dismissal. Say, for instance, before you were assigned in an office full of, shall we say, the compliments of the employer. Merong coffee maker, may jacuzzi pa. No? Tapos meron pang newspapers every day with a split-type aircon. Later on, you catch the eye of the company, you were assigned in an office where there is no aircon. But you were given a 1945 vintage electric fan. Yung pag-iikot 1 second every ano. Wow, galing naman. Anong gustong ipalabas ng employer yan? To compel you to resign. So, when the disdain acts, ano sabi ng Supreme Court? When the disdain acts are unbearable, the employee has no option but to abandon his position by tendering his resignation, which amounts to constructive dismissal. Tingnan niya? All right. HR is perilous. Ang sakit na ng pit ko. Hindi niyo papansin. Paikot na ako, paikot. Wala namang aircon dito sa ilalim. Mainit. All right. Listen. I will now discuss to you the filing of a case of illegal dismissal until it reaches the Supreme Court. Makinig kayo mabuti. This is also a bar area. Lalo rin sa requirements of an appeal from the labor arbiter to the NLRC. So listen. All right. By the way, for violation of the constitutional rights of workers to due process, a case of illegal dismissal can be filed. Where will you file the case of illegal dismissal? Sabi ng iba, in LRC. You should be emphatic in your answer. It shall be filed with the regional arbitration branch of the NLRC having territorial jurisdiction over the workplace of the complainant. It is the workplace of the complainant that determines the venue where it shall be filed. So if you were an employee in Manila, you reside in Pampanga, you were dismissed, you file it in the National Capital Region. If you were an employee in Pampanga, you are a resident of Manila, you file it in Region 3. Yan ang ibig sabihin niya. You file it with the regional arbitration branch of the NLRC having territorial jurisdiction over the workplace of the complainant. Okay. Listen. Is there a specific form required by law in a complaint filed? No. No specific form. Pwedeng mere complaint, mere affidavit of complaint, notarized or subscribed before an administering officer of the NLRC. Pwede yun, no? Or it's a pro forma complaint or a complaint where you just fill in the blanks. Nandiyon, name, complainant, age, address, first day of employment, nature of the job, date terminated, etc. Tapos yung reliefs, reinstatement, actual, o kaya dismissal, actual dismissal, constructive dismissal. Ano pa? Other reliefs paid for. After which, you file it with the regional arbitration branch. First of all, you let it be docketed in the docketing section. Kapag dating sa docket section, i-receive ngayon yon, meron ng case number or docket number. After which, you are required by the docketing officer to proceed directly to the ELA. You know ELA? Executive Labor Arbiter's Office. For purposes of what? For purposes of bola-bola. What is bola-bola? English. Raffle daw. Sa English, yung bola-bola, raffle. Oh, galing, ano? Kaya bola-bola is raffle, ano? So, it shall be raffled with the Executive Labor Arbiter's Office. Merong bola-bola ron. Nakalagay. May mga bola-bola. Iraraffle ngayon. Bumagsak yung isang bola. Number 69. Number 69. Titignan ngayon ng raffle officer. Sino itong number 69? Pumunta ka kay Labor Arbiter Bugan. Sabing ganun nung Labor Arbiter Bugan. Kilala niya? Ay, hindi niyo kilala. Si Lily. Imagine hanggang ngayon, hindi niyo kilala si Labor Arbiter Bugan. Punta ka kay Labor Arbiter Bugan. It will be, yung raffle slip will be signed by the raffle officer. Pupunta ngayon kay Labor Arbiter Bugan. Pagdating doon, merong labor associate, o clerk, o secretary, or the labor arbiter himself. And this will be scheduled for the first two preliminary conferences. First and second. What is the purpose of the preliminary conference? Diniscuss natin to kanina. For purposes of amicable settlement. Pwede pa. Now, so, during the first preliminary conference, if you were a good labor arbiter, you can really terminate the case right away, right then and there. Kung magaling. Panyero, anong pwede mong gawin dito? Sabihin mo sa, and take note, you should not act with braggadocio. You should not be haughty. Hindi dapat kayo mayabang. Be humble. Ganon. Pwedeng ano. Well, if Your Honor, please, I will consult my client if he is amenable on any settlement of this matter. If Your Honor, please. Ganon. Huwag yung, porket kayo ay matanda ng abogado, ikaw ay book author, o bar reviewer sa labor law, huwag niyo sasabihin na, huwag niyo ipamamayabang yan. Actually nga, itago mo nga eh. Yung hindi niya alam, hindi nila alam. Alright. Assuming that during the two preliminary conferences terminated, walang amicable settlement, could there be still another resetting for an additional conference between the two parties? Yes. Until finally, that there is no settlement made, and the one given under the law, the discretion to determine whether or not a position paper proceeding or a trial type proceeding shall be had lies with the labor arbiter. So, assuming that the labor arbiter decided to require the parties to submit simultaneously their respective position papers, known as the position paper proceeding. Now, question, is the position paper proceeding a violation of due process? This is an actual case. Is it a violation of the due process clause of the Constitution? Sabi ng Supreme Court, no. The fact that the parties are given the opportunity to submit pleadings, such as position papers, their answers or rejoinder, as the case may be, the parties are already given the opportunity to be heard. Secondly, technical rules are not binding but resort to amicable settlement. So, technical rules of procedure and evidence are relaxed in labor proceedings because the purpose of labor law is the administration of speedy labor justice. Very good. Tingnan nyo, pag yan ang mga pag nilagay nyo sa bar, wow, sasabihin ng bar examiner, pwedeng maging bar reviewer to. Sabi niya, imagine, bar reviewer ka agad. Magaling to. Speedy labor justice. Ako, hindi ko alam. Sabi na nung bar examiner, hindi ko alam to speedy labor justice. Alam nito. Oh, instead na 75, giwan 95. Tignan niyo. All right. May any one of the parties move that the proceeding will be on a trial-type proceeding? Yes. But still addressed to the sound discretion of the labor arbiter. Okay. So, assuming no settlement reached by the parties, the labor arbiter requires the simultaneous submission of procedures on a particular date. Okay, dumating sila. For which after, it will be, what? The parties will again required to submit an answer to the respective position papers. Under the new rules, wala na yung rejoinder kasi sabi ng NLRC, it is a repetition of previous pleadings. Totoo yun. Repetition lang palagi yan. But, take note, hanggang ngayon, ginagamit pa rin namin yung rejoinder. Now, ano ang legal anchor again doon? Article 221. Take note, you become a lawyer because of Article 221. Technical rules are not binding but resort to amicable settlement. Okay. So, when the final pleadings are submitted, perhaps the parties may agree that is deemed submitted for resolution. And under the Labor Code of the Philippines, the labor arbiter is given how many days within which to resolve the case? 30 days. Okay, so 30 days. Assuming that there was a decision finding illegal dismissal. So the decision provides, among other things, what? Reinstatement, pullback wages, damages, attorney's fees, payment of 13-month pay. Oh, meron. So what happened? Upon receipt by the complainant employee, there's no problem. He's the prevailing party. Nanalo siya. What about the the losing employer? How many days within which to file an appeal? The employer, the losing party, has 10 days. Calendar or working days? Calendar days according to the Virgen shipping case. 10 calendar days. Again, ang rito, speedy labor justice. Ang legal anchor dito. Alright, 10 calendar days. Exclude the first day of receipt. Include the last day. So, the reckoning period yon, 10 calendar days. Now, the receipt of the party or the receipt by the lawyer, which is the one provided for under the law. Receipt by the party or receipt of the lawyer on record, which is the reckoning period in determining the 10-day calendar day period. It is the receipt by the lawyer on record, counsel on record. Several counsels, the receipt of one is sufficient. Okay. Assuming that upon the expiration of the 10-day reglementary o regla? Ang dami nagkakamali rito. Regla ng regla. Sinabi ko rin sa isang abogado, anong hilig mo naman sa regla? Dapat regle. Hindi, regla. Tingnan mo yung rules kako. Regle. Pero Espanyero, kasi mahilig ako sa regla. Bakit? Sepis period. Sabi ko, Messi. Yak! Yak! Bastos. Grabe. So, it should be regle, not regla. Tandaan niyo yan. So, here, 10-day reglementary period to appeal. Okay? So, if the 10-day reglementary period to appeal has expired, upon the expiration, the decision of the labor arbiter becomes final and executory to a certain date. In other words, the decision of the labor arbiter has to become final and executory at a certain date. Otherwise, there will be an unending litigation under the principle or doctrine of under the finality rule. Tama rin. Pero mas maganda, may impact under the doctrine of immutability of final judgment. Yan ang banat dyan. Under the finality rule, alam na alam yan. Pero anong may impact? You should have impacted, hindi impacto. Under the doctrine of immutability of final judgment. Do you follow? That a decision must necessarily come to an end, otherwise there will be an unending litigation. All right. So, there was no appeal made by the losing party. There's no problem. As to the reinstatement aspect, it is immediately self-executory. But as to the other awards made by the labor arbiter, there is a need for a writ of execution. The writ of execution, according to the Supreme Court, is the fruit of the case, which in Latin term is known as writ of fieri facias, hindi capias. Fieri facias. Hindi nyo makakalimutan yan. Fieri facias. Now, writ of execution. Okay? So, you file a motion for the issuance of a writ of execution. Upon receipt thereof, shall the labor arbiter issue right away a writ of execution? No! He will notify the parties for a pre-execution conference. Pre-execution conference muna. Alam nyo, ginagawa ko yung pre-execution conference na yan. Pwede kayong mag-haggle dyan. Pwedeng magkaroon pa ng settlement dyan. Bumaba yung hinihingi ng judgment award. No? Kung magaling ang abogado dyan, ginawa ko sa isang kaso ko talon 5 million ang award Final and executory, nag-file ako ng motion to quash. You'll be notified for a hearing. Kinausap ko yung abogado. Panyero, sabi kong ganun. Ang daming writs of execution kami. Sa inyo, 5 million. Sa ibang kaso namin na writ of execution against sa amin kasi manning agency. May 5 million, may 10 million, may 15 million. Mas nauna pa yun. Yun ang uunahin ko kaysa yun sa iyo. Panyero, bayaran mo na ako na bahala. Tinanong ko yung kliyente, sa 5 million, magkano man pwede mong ibigay? Sabi niya, attorney, kasi wala tayong pan 13-month pay, kung ibibigay natin lahat yan, pwede na ako 1.5. Ano yun? Unconscionably law. Pero in actual practice, nangyayari yan. Pero under the law, bawal yun. Unconscionable law yan. Kasi sa deed of waiver and quitclaim, ilalagay mo 1.5 o 1 million, bawal yun. Pero, kumisan, ayaw na nila ng mga ibang parties na tumagal pa. Di, sabi ko ron sa kumpanya, 1.5, attorney. Sinabi ko ron sa pwede bang bigay mo na ron sa doon sa kliyente mo, 1 million? Naku, ang baba naman, attorney, 5 million, nasa against 1 million. Wala. Wala na rin kayo makukuha. O makukuha nyo rin, computer namin na, na virus pa. So, kung gusto mo. Sige, tawagan kong kliyente ko. Pumayag sa 1 million. Sabi nga, wow. Merong margin ako, 500,000 Wow, 1 million. Sabi niya, Panyero, paano yun sa akin? Baka pwedeng may attorney's fees ako na hindi na alam nung kliyente ko. Meron ka na naman dyan. Hindi. Sige, ako na bahala dyan. Tatawagan ko kliyente ko. Pumayag, 200,000. Sabi ko. Di, ang ganda, Panyero. Sabi, paano naman ako? Diyos ko. Sabi niya sa akin, sige, hatiin na natin yung 200,000. Tandaan niyo to, kahit nabagsak na ang kliyente niyo, talo na kayo, do something. Kasi pag sa talong kaso, diyan kayo kikita. Ano malay niyo? Mag-file kayo ng postponement palagi. Bakit? Ano malay niyo? Mamatay yung kalaban ninyo. Nangyari sa akin, kaya alam ko yan kumita pa ako. Magkano kinita ko? 400,000. Yung alam problema, yung binibigay ng kliyente, cheque. Sabi ko ron sa kliyente, wag, kasi may mga bibigyan ako mga ibang tao ron, gusto kasi hindi pwedeng cheque. Kaya i-voucher mo yung 1 million as, sa check, yung 500,000 cash. Sige, attorney, kayo po bahala. Pinasamahan ako hanggang doon sa Bookman Building, kasi doon ang, I will not mention the labor arbiter. Siyempre, binigyan ko rin. Panalo na naman Sabi niya, Panyero, 1.5 million lang to. 1 million. Pero pinipirma namin 1.5. Sabi ko, ano bahala siya? Ikaw naman. Yung kalaban ko, abogado, hindi niya alam kung saan niya ilalagay yung 100,000. Kasi I see to it na tigwa 100 pesos. Di ang kapal ngayon yung hindi niya alam saan ilalagay. Tandaan niyo yan, Kahit napatay na ang kaso, buhayin ninyo. May kita point na magkaroon ng settlement. Kasi sa settlement, doon kayo kikita. Sa actual practice niya. Pero dito, pakinggan niyo muna ako yung theory. Yung theory muna. Unconscionably law. It's against public policy. Tandaan yun, against public policy yan. Okay, let's continue, people. Now, so there is a writ of execution. Finally, a writ of execution is shall we say, issued by the labor arbiter, directing the sheriff to execute the judgment of the labor arbiter. Now, what happened? Thereafter, may nagbayad, partial payment. Now, wala na kami babayad. So you go after what? Yung mga deposit, through garnishment proceeding, Iga-garnish mo ngayon yung mga Tapos, pag hindi sufficient, you levy the property, as the case may be, until it is fully satisfied. By the way, in the meantime, if writ of execution is filed, is issued, you can file a motion to leave. Binigay yan sa bar, one time. What are the instances under the law or under existing jurisprudence where a motion to quash can be, where a writ of execution can be lifted through a motion to quash or a motion to lift writ of execution? if it is irregularly issued, if the judgment award is not complete or inadequate, or it is issued on the ground of graft and corruption, fraud, yan. It was issued to a non-party. Mga ganon, no? So these are some instances under the law and under existing jurisprudence people where a motion to quash can be filed on these grounds or instances people. Now, assuming nag-file ng appeal ang employer, the losing party, what are the grounds? Fraud, graft and corruption, grave abuse of discretion, serious errors in the findings of facts. Okay. What are the requirements for appeal? First, payment of docket fee, appeal fee, filing fee. Pre-preho yan, ha? Filing fee, docket fee, appeal fee. Pareho yan. Now, it is settled by the Supreme Court that the payment of docket fee, appeal fee, or filing fee is a jurisdictional requirement. Otherwise, the appeal will be dismissed. Another, submission of the memorandum of appeal. Copy furnished the other party. But if the other party is not copy furnished with the memorandum of appeal, is this fatal to the appeal? Sabi ng Supreme Court, it is a mere procedural, formal lapse, which is not fatal to the appeal. Again, what's your legal anchor here? Article 221. Tandaan niyo yan. Article 221 of the Labor Code. All right. Doon sa memorandum of appeal, of course, what are the proper, shall we say, embodiment of the memorandum of appeal or appeal memorandum? We have the caption of the case, then the title, memorandum of appeal for respondents, memorandum of appeal for the complainant, etc., or the appellee, etc. No? Respondent by and through the undersigned counsel and to this Honorable National Labor Relations Commission respectfully submit this memorandum of appeal and allege the following as the case may be. No? Parties, we have statement of the facts, the statement of the case, ano pa? Issues, assignment of errors, then after that, discussion, arguments, then after that, you have to pray. You know, you are prayerful people. There is always a prayer. No? After the prayer, now, halimbawa, taga Quezon City ka, you have to file it in Quezon City, the Quezon City, Philippines, the date, then respectfully submitted. If it is represented by the law office, the name of the law office, the address of the law office, by, kung sino yung representative counsel, kung ako, Attorney Salvador Poquis, roll number 31953, ganun. Oh. Tapos, IBPOR number, PTROR number, MCLE compliance, exempted ako. Tapos yung date of exemption. Pagkatapos nun, verification and certification on non-forum shopping to avoid multiplicity of suits. Pagkatapos, personal service. If personal service cannot be had, then sabihin nyo, there must be an explanation to that effect. That personal service cannot be done because of the distance of the parties, or there is no sufficient personnel in the law office because the law office has only one lawyer. There's only one lawyer, no? Oh. Tapos, signed by the lawyer. Yan. Memorandum of appeal. Now, posting of an appeal ban, supersedious ban. Appeal ban may be in the cash or surety ban. Does the labor arbiter fix the amount of the ban? No. It is the law that fixes the amount of the ban. Ano sabi ng law? The ban is equivalent to the monetary award minus damages and attorney's fees. So damages and attorney's fees cannot be included in determining the amount of the bond. Now, question. May the appellant party file a motion to reduce bond. The rules allow a motion to reduce bond, but it shall be filed within the reglementary period to appeal, within 10-day reglementary period to appeal. But it's not a mere filing of the motion to reduce bond. Ano ang requirement ng Supreme Court? The requirement of the Supreme Court is this. Aside from the motion to reduce bond, this shall be coupled by the posting of a reasonable amount of the bond, meaning partial bond. Nag-file ka nga ng motion to reduce bond, walang posting of a reasonable amount of the bond or partial bond, that will be dismissed. Now, question. Dito naman sa appeal, under Article 128B of the Labor Code, yung sa inspection power ng the Secretary of Labor or through the regional office of the Department of Labor and Employment, does the law allow reduction of bond, posting of the reduction of an appeal bond under Article 128B of the Labor Code of the Philippines? If it is appealed to the Secretary of Labor from the regional office to the Secretary of Dole, the law does not allow reduction of an appeal ban under Article 128B. But it is allowed under appeal under Article 223 of the Labor Code of the Philippines. Ba't yun lang ako tinitignan na ganun? Parang namamangha kayo. Ha? Okay. So take note of this, no? Posting of an appeal bond. By the way, there are only two types of a bond. Cash, surety. What is the exception? The exception is the UERM ruling. Ano sabi ng UERM ruling? Property bond can be posted if the amount of the property is substantial enough to cover the monetary award. That is the UERM ruling. The bond posted cannot be replaced by an irrevocable bank guarantee or a bank certification. Nag-file ka na, nag-submit ka sa NLRC. Meron akong bank certification ng award, 10 million. Pero I have in my bank 15 million. Ito certification. Is that sufficient? No. The Supreme Court said, you have to file an appeal bond. Either in two. Ano yan? Cash or surety. An exception lang yung property bond under the UERM ruling. All of these shall be filed or submitted to the labor arbiter aku. Alam niyo yun? Labor arbiter aku. Ako. Doon yung isa-submit, after which the labor arbiter will transmit the records of the value of the case to the division of the NLRC having jurisdiction over the appealed case. Hindi diretso sa NLRC. Division, no. Doon sa labor arbiter ako. Parang na Koreano. Okay? Now, while the case is pending appeal, doon, of course, among the commissioners, there will be consultation as required by the Constitution. And to the effect that there is there's a certification to the effect by the presiding chairman that indeed consultation was conducted among the commissioners before its assignment to the ponente of the case. Now, yung ponente ngayon, ano nangyari? The ponente notified the parties for purposes of amicable settlement. You know, I have several cases which were under conciliation, under settlement through conferences where we were notified by the commissioner. Is settlement pending appeal allowed under the law? Yes. What is the legal anchor again? Article 221 of the Labor Code. Very good. Alam nyo na ngayon yan. Imagine, you will become a lawyer because of Article 221. Technical rules are not binding but resort to amicable settlement. Because the purpose of labor law is the administration of speedy labor justice. Ganon. Another. Halimbawa, may mumu ata dito. All right. So, pending appeal. If you were required by the commissioner for a conference for purposes of settlement, give due respect. You know, I had the occasion where my case before now Justice of the Court of Appeals, si Justice Gakutan, ng commissioner ng NLRC dati. You were notified by her for purposes of amicable settlement. Ang nakalabang ko rito si RJ Jacinto. Natalo namin siya. Natalo ko siya. Nag-appeal sila. Ang kalabang ko, yung abogado nila, pare. Ang yabang ng pare. Panyero, can we still settle this so that we will not decide on this on the merits? We can have this under settlement. Well, if Your Honor, please, we are amenable for any settlement. I don't know with the other party. If Your Honor, please. Sabi nung abogado, yabang. If Your Honor, please, I cannot decide now because I have to consult first my client, RJ Jacinto. Nako, mayabang to kako. Patay to sa akin kako. So we set for another conference. Hindi dumating. Binanatan ko na. Sabi kong gano'n, alam mo, Commissioner Gakutan, kumisan may mga sira-ulong abogado eh. Bakit? Sabi niya, tignan mo, hindi tayo nire-respeto. Kayo, hindi kayo nire-respeto. Nandito kayo, hindi kayo nire-respeto. Hindi man lang umatin, hindi man lang nagano. Para hindi na ako pumunta rito. Meron pa naman akong kaso sa Pangasinan. Inano ko na lang ibang kasama namin sa law office. Alam mo, Panyero, pasensya ka na. Pwede bang i-reset natin? Sige. Another resetting, hindi na naman umatin. Sabi ko, yan ang mahirap. Kung minsan yung mga ibang abogado, walang modo. Pero hindi ko naman gagawin pag nandun yun. Alam mo, walang respeto kung minsan commissioner eh. Yun nga eh. Sige. For resolution na ito, Panyero, as you wish, Your Honor, okay lang sa akin. You give me 1 to 2 months to decide this. Okay lang yun, Your Honor, please. Kahit ano. Wala pang 2 weeks, dinesisyonan eh. Talo. Kasi, you give due respect. Pag ganyan, you give due respect. Don't antagonize the judge. Even if the judge has only faced the mother can love. Yung bar examination ni Justice Natura. A face that a mother can love, that can only love. Imagine. You attend. You give due respect. Don't antagonize the judge. Nandyan ang buhay nyo. Kikita ka pa. Kikita ka. Tandaan niyo yan, ha? Alright. Assuming nagkaroon ng desisyon ng ang NLRC finding o affirming in toto the decision of the labor arbiter. Of course, as to the reinstatement aspect, as I've told you before, it is immediately self-executory under the labor upon the expiry upon the issuance of the decision. No? Now, again, while reinstated in the payroll, talo na naman yung employer. You file a motion for reconsideration. What is the purpose of the motion for reconsideration? The law only requires one motion. A second motion is a prohibited pleading. A motion for reconsideration, what is the purpose? To rectify any error committed by the NLRC. Yun ang isang purpose. Another purpose. Of course, another purpose is this. Why you should file a motion for reconsideration. Ano sabi ng Supreme Court? A motion for reconsideration is a condition sine qua non prior certiorari. You cannot go on certiorari until and unless you have filed a motion for reconsideration. If the motion for reconsideration is denied, then from receipt of denial, you have how many days? Under Rule 65, we have 60 days from receipt thereof to file your petition under Rule 65, which is actually a special civil action for certiorari, which is initially filed pursuant to the St. Martin's ruling, which is initially filed with the Court of Appeals under the doctrine of high hierarchy of courts, or pursuant to what? Administrative Order 1-95 issued by the Supreme Court under the doctrine of high hierarchy of courts. If you have complied with all the requirements under Rule 65 with the Court of Appeals, of course, not necessarily giving due course to your petition, the other party may be required to submit its comment. Again, the decision of the NLRC was affirmed again by the NLRC, by the Court of Appeals. Kawawa yung employer. You file again a motion for reconsideration. It is denied. You have 15 days under Rule 45. Mag-expire na. Can you file a motion for extension of time? Yes, another 15, but not to exceed 30 days. Until finally, you file your petition under Rule 45. Finally, the Supreme Court found legal dismissal. Now, the petition you filed with the Supreme Court is confined only to questions of law. Are factual findings under review by the Supreme Court? As a general rule, no. What is the exception? According to the Supreme Court, if the decisions of the labor arbiter, NLRC, and Court of Appeals are contrary with each other, one case. Another case, in collision with each other, in collision with each other, one case. Another case. Another case, in collision, contrary, or another. The decision of the labor arbiter, NLRC, Court of Appeals are diametrically opposed to each other. Ano pa? Lastly, lately, the decisions of the labor arbiter, NLRC, and Court of Appeals are divergent. In other words, they have divergent conclusions. Then, factual findings of these bodies akuo can be subject to review by the Supreme Court. Pagod na ako. Uwi na tayo? 8 lang eh. O sige. By the way, upo muna kayo. Pagod na rin ako. So tomorrow, tinapos ko lang yung book 6 and 7. We will still continue with labor standards and labor relations tomorrow. I will try my best, with my very best, to finish this. All right, so you just remain in your seats and let's thank the Lord and pay back the Lord for the life He has given us. In the name of the Father, the Son, the Holy Spirit, Amen. Father God, maraming salamat po. We are here to discuss on pertinent areas of the bar. Alam namin po, Lord, na halos lahat ng namin didiscuss ay pwedeng ibigay po ng inyong anak na bar examiners, kung sino man siya. Ikaw na pong bahalang mag-feed sa kanya kung ano mang mga bar questions niya na galing sa amin ni lecture, Lord. Ikaw na po bahala, Lord, and give us the strength and the guidance and the light for us to finish this chosen activity, this monumentous activity. And Lord, ikaw na po bahala. Sana po lahat maibigay yung diniscuss namin para po yung mga anak mo ay maging abogado, abogada, at matawag silang attorney. In the name of the Father, the Son, the Holy Spirit. Amen. Pagod na. Ha? Pagod na ako. Bukas na. Dire-diretso na.
Hindi kayo dumas sa office eh.
Hindi na.